Hello, everybody.
Welcome to Commit to Acquit.
Episode 2. Um, we are going to start with Lively v. Wayfarer, since we know that's what most people are here for. And we're going to start by going over the motion for summary judgment and motion for judgment on the pleadings.
Full disclosure, did my very, very best to think of the most positive, the evidence in light of Blake being right and what is her best evidence.
Mhm.
And so I'm going to try and present that today. But I'm going to be honest, there were a couple times where I was like, well, that PGA letter really screwed you on this claim, didn't it?
It is a remarkable document.
It is a very remarkable document.
Let's see. Okay, so do you want me to share, or do you have it pulled up?
I have judgment on the. You want to start at judgment on the pleadings? Let's pull it up for everybody.
Do you have it? Do you have an option to share on the bottom?
Do I have an option to share? That
should say present or invite, and then click on it, and it'll say share screen.
I want everyone to know that I am a millennial. Okay, so can you see this?
You have to click. I think it clicks like put it on the screen. So even if you have it on the bottom, I think you have to click something and then it puts it up on the screen.
The browser can't access your screen. Try capturing a different screen to see if this continues. Those are words. Those are certainly some words. Again, everyone, thank you for the technical difficulties.
I can pull it up if that works. Okay, so we're going to start up here. Did you want to start with the judgment on the pleadings?
Yeah, I think that's a better place to start just because it's purely procedural.
Okay. So I did kind of wondered if you could maybe give a little bit of an explanation of conforming the pleadings to the evidence.
Yeah, I mean, it's kind of just how it sounds, right? Instead of, hey, judge, maybe I didn't make the most accurate allegations in my complaint, right? Maybe my complaint doesn't rise to the level of what the allegation should have been.
Mm-hmm.
But now we've gone through discovery and we've discovered some things that would prove allegations that we didn't have in the complaint. So whatever deficiencies we had in the complaint that allows somebody to dismiss, we should conform the pleadings to the evidence. And it's kind of like converting it to a motion for summary judgment, but now allow us to introduce evidence, even though we didn't make fully fledged allegations. Let us use this evidence to suffice, to fill in the gaps of where we maybe went wrong in the pleading. Because a judgment on the pleadings is just that. It's saying based on all of the allegations you made, even if we assume those are true, you don't have a complaint here. The law does not give you relief based on what you've alleged. And sometimes, right, that's, say you're alleging breach of contract, which means you need a contract, you need a breach, you need causation of your damages, right? And say you say, okay, there's a contract, there was a breach, damages, right? And you don't allege anything about how that breach caused your damages.
Right.
I would come back and say, motion to dismiss because you don't allege causation. So what they're saying is those missing pieces should be conformed to the evidence.
Right. And this is just to prevent having to kind of go through the dismissal and then you refile and have to kind of go back and forth, right? It's not something that's unfair that she's asking, right? It's just...
Right.
It's
typically...
Right.
Typically, a judge will give you the chance to amend your complaint.
Right.
As we have seen with Wayfarer's complaint, that was not the case. Which now that we have evidence, I think they probably have a pretty good case, at least against Ryan Reynolds.
Hopefully we get that motion for reconsideration, right?
I would love them to file that motion for reconsideration, but I don't think it's coming.
I don't either, but we can hope.
A girl can dream.
Yeah. Let's see. Okay, so that's just... I tried to explain that. I think I'm glad I got it right. I kind of just read a legal dictionary and then...
I mean, that's your best bet.
Let's see. Okay. So let's start with, I guess, so let's start with the first kind of argument, which is the extraterritorial application of FIHA. So Wayfarer is arguing that FIHA does not apply because this film was made in New Jersey, and FIHA has a California law that has to do with employment. So basically, California Labor Code's FIHA, it doesn't apply because none of this happened geographically within the state of California. And then, so the simpler version, FIHA does not protect non-California residents, and the employee or employer's residency is not sufficient to overcome the presumption that FIHA does not apply when the tortious conduct occurs outside of California. So I see you've written things.
Yeah. So within this argument, Blake really relies on the actor loan out agreement, which I'm going to call the ALA, which everybody's been calling the ALA. So the fundamental issue is not the territorial reach of California statutes, but the party's contractual choice of law. That's her argument, right? So doesn't matter that we recorded in New York, New Jersey. We agreed in our contract that California law applies, right?
Right.
If the actor loan out agreement is not a valid contract,
right,
this argument doesn't hold water. And the judge was kind of tipping his hand a little bit, it seems. I obviously wasn't there. I've only listened to people recount it. But the judge was sort of tipping his hand that he may not agree this is a valid contract. So it'll be interesting to see what he finds on that. And choice of law, basically, for the most part, if two parties agree to something in a contract, the court will uphold it. So if you and I enter into a contract, you're in Colorado, I'm in Arizona, but we decide California law applies, for the most part, courts will uphold that. Now, sometimes they won't.
I mean, I guess my question is, for employment law, doesn't that kind of create an issue? Because what if the employment laws you're agreeing to contradict with the employment laws where you're doing the work, right? Like, if you're in Arizona and I'm in Colorado has a higher minimum wage than Arizona. We can't agree that you're only going to pay me Arizona minimum wage.
Right.
You still have to pay me Colorado minimum wage. So there's limits with employment law, right?
Right. And that's really where this is one of the stickiest issues. We have a federalist system, meaning there's a federal set of laws and each state has its own set of laws, and it gets really sticky and complicated when you have these interstate workplace issues, right? Where we have some parties live in California and some parties live in New York and they're doing work in New Jersey, and which law applies. And this is something that has come up over and over. I do just the nerdy, I love civil procedure. I geek out on this stuff. So I'm just like, what's the judge going to decide? I'm really excited about this one. Something else that she kind of relies on is that, they're saying California has a statute that says our laws don't apply to citizens outside of California.
Right.
And they're saying, but this statute in itself doesn't have that extraterritoriality. Now I can't say it.
Yeah.
Okay. Did I do it?
Yeah, you did it.
I can't do technology. I can't do words.
That's why I'm here.
Yeah. That's why we have Sara. She's the smart one. And I'm
the paralegal. You're the legal. I'm the paralegal.
Yeah. So they're saying these statutes don't have that limitation. Right. So we can apply these statutes because they actually don't limit themselves, probably for this very reason. For movies that are made, the unions and the actors oftentimes are based in California, but they're filming in Georgia or they're filming in New Mexico, and they still want to be able to apply California law, which I think is probably pretty fair. They have a certain set of expectations if they live and work in California for the most part. And, they filmed The Walking Dead in Georgia. That's not fair that now Georgia law applies. I can't imagine Georgia has favorable. And I named those two states because that's places where a lot of stuff is filmed. So
yeah.
And then, she points to a lot of pre-production decisions from California. I really don't know how much those will hold weight, but the statement of she'll be birthed into the role was made from California.
I don't know if you saw it. Did you see where that's from?
He was texting Ange, wasn't he?
Yeah, so it's like she didn't even know that's not, she wasn't even in the conversation. She would have found it in discovery.
Right. It was
like,
so sexually aggressive. You didn't even know about it until you filed this lawsuit.
right. Like, I don't know. It's just,
yeah.
So yeah, I mean, and I noticed here you said the Wayfarer lawsuit asserts California law. They did say something like this is not reserved, like forfeiting the right to dispute this later, right?
Right. And right. So
yeah.
in their lawsuit, she says they're foreclosed, meaning this court should not allow them to make this argument that California law doesn't apply because they applied California law in their lawsuit.
Right.
But in their lawsuit, in a footnote, they said California law may apply.
Right.
And we reserved the right to argue that it doesn't.
Yeah, just because they argued that it does doesn't mean they're going to win on it. This kind of reminds me of in the Jones v. Abel case, they're trying to add Jamie Heath as a defendant. And he said, well, I haven't consented to jurisdiction in the Southern District of New York. And people were kind of surprised at that. But it's like, yeah, just because he's in Lively v. Wayfarer consensually and saying that Lyman has jurisdiction over him for this case doesn't mean he's consenting to jurisdiction everywhere else. He could be dismissed like Jed Wallace was.
And it's a different set. It's a different set of facts. They overlap a little bit, right?
Yeah.
But now we're talking about his employment agreement with Stephanie Jones that she probably very definitely breached, right?
Yeah.
And you're talking about business relationship with his ex-publicist. It's a very different world of facts that maybe he doesn't want New York judge deciding that because he's like, I live in California or who knows where he lives. I'm not trying to dox him, so.
But yeah, I just thought that was funny because he's like, well, I never said I have personal jurisdiction in Lyman's court. And I was like, I forgot you can do that.
Yeah.
You can just say it's okay for some cases, but not others.
Yeah. You're not just indefinitely pulled into that court because one time you were sued there.
Yeah. Let's see. Okay. And then we've got during a pre-production Zoom meeting with producers, Mr. Baldoni, joining from California, lashed out at a female producer and later sent an apology from California acknowledging that he had mansplained and been dismissive. I guess this is another thing. I know that Judge Lyman said in the oral arguments that Isabella Ferrer's stuff cannot come in because Lively was unaware of it at the time that she was filming. So he said if she didn't know about it, she can't use it. Can she use this?
I don't think she can use the births into the role statement.
Okay.
I don't think she can use this. I think it depends on when she found out about this.
Okay.
I also don't think this to me feels like character evidence that gets a little sticky, right?
Right.
So he can kick down the door and say, I've never yelled at anyone ever.
Mm-hmm.
Do you remember Alex Sachs, right? And now we can get into stuff that he's done on set. But it sort of feels like character evidence is meant to bar the kind of testimony and evidence where somebody gets on the stand and says, look at what a bad guy the defendant was here. Right. They must be a bad guy always. Look, he yells at women over here. They must be a bad guy always. But, you know, as far as Blake's claims go, that goes towards how he treats women.
Right.
And that's going to be her argument is, look, this is how he treats women. He's not yelling at male producers. He's not yelling at Jamie Heath.
Right.
Right. He's not yelling at the camera guy or the set production guy, you know, or whatever. He's yelling at women and he's being disrespectful to women. So that's how Blake will use it. I think Wayfarer keeps it out through that character evidence, but
it seems like something they could kick the door down on pretty easily.
Yeah, I think it will come in.
Okay.
I think you make the argument it's not admissible. I think it comes in. I also don't know, and I think you could speak to this. Mm-hmm. I don't know that this is persuasive to a jury. Okay,
absolutely not. I think that one of the dangers here is if you have too many things like this that are too low stakes, you wind up making the jury think that you're too sensitive.
Right.
And so then the question becomes, especially because for some of these higher level claims like the dance scene and the trailer incident, we're going to have people with different stories and we're going to have some credibility issues. So you run the risk, if it feels like you're overselling some of these smaller incidents that did happen, that it's like in hindsight, you're just scraping everything up that you can use to build a case.
Right.
And then that leads the jury to think that maybe you're not being honest when it comes to the bigger incidents where we know she's kind of building the case around. harassment.
Right. Yeah. I do find that even when character evidence comes in, and I don't do criminal law, which is where a lot of that kind of stuff comes in.
Yeah.
Right. But I do find that people tend to be like, okay, so he yelled at a producer he was having issues with. And we know she was getting snarky with him, right? We know she's trying to undermine him. She's encouraging Blake to fire people and all that. So of course they're having issues. So they got into it and he yelled a little bit. And now I'm to think he's a sexual harasser?
Right. It reminds me of, like, do you remember the series finale of Seinfeld? Where they just bring in every single person that's ever had an issue with them to come in and testify to, like, how bad all these people are. Yeah. Like, you run that risk where the jury feels like that's what you're doing. Like, you've just kind of, you've got a phone book out and you're just like calling everybody, say, hey, has Justin Baldoni ever personally offended you? We need you on the stand.
Right.
Which I think is the other thing with the Claire lady, that Claire Ayub recording. I think her declaration was written so that it could admit character evidence, because I think to get that recording in, now you have this declaration, and now it's like, can we get this in too? Because now she's saying that the reason she did it was because of Baldoni. So now if she goes and testifies, they can ask her about that. I think that was the logic, right? Tying the recording to Baldoni however you need to try and build that. But then it's the same thing. It's like, I don't know if a jury's gonna be like, really?
I think a jury would more likely feel the way people felt when they read the declaration and then heard the audio, and they were like, these two things are not the same. One of these things is not like the others.
Yeah.
I think once you play that audio, and again, I just don't know that it's relevant, right? It's another set that he wasn't working on. He denied her some funding and she got a little pissy about it.
Right.
Okay,
it just doesn't match with what Sarowitz is saying, right? Like, he's saying to Claire in the audio, like, everybody who's worked with Justin loves him. So I'm like, well, he clearly doesn't know that you've even met, much less that you've had issues, if he's saying that, right?
Right. She says the purpose of this call is to say she doesn't want Justin doing her promo.
Yeah.
And then she never says that to him. Right. When he brings up Justin, she's like, oh yeah, oh okay. I don't know what it's like on his sets. Like,
yeah.
Right. So I honestly, if Claire gets on the stand, she would be so fun to cross-examine because you can impeach her so fast.
Like, okay, let's see.
This was your audio, right? You said this, and then later you said this, right? It would just be fun to destroy her credibility on the stand.
I just want to hear her explain how having a secret recording of him asking Justin to do the promo helps her. Like, if she had said, I'm recording this at the beginning of the call, maybe he doesn't ask, right? But okay, you've got this secret recording where he says, put Justin in the premiere. He didn't say that, but let's say he did, right?
Right.
What does that do? What is it that you're planning on doing with the audio? Are you just going to send it to TMZ because they're in the middle of a PR battle with Blake Lively?
Right.
And she can't say, I think she could say eventually, but she can't technically say, well, I knew she got sexually harassed, because then she'd have to explain how she knew that, because it's not in the media yet. So did you have a conversation with Blake before?
Right.
And it just, Jesus.
I mean, you can unravel her testimony so fast. She's not a good witness for Blake. I doubt she gets called at trial.
Probably. They may just abandon this whole recording.
I mean, the 9 women that everybody's
she
must
be one of them.
She's one of the 9 women online, and it's like, she doesn't do anything for their case. She doesn't mention sexual harassment. She doesn't even really mention being harassed. I mean, she does in her affidavit, but the real-time evidence is not really showing that.
Right. It's just another, I guess she's serving her purpose as part of this 9 women narrative.
Sure. I mean, it's for the court of public opinion.
Yeah.
Full stop.
This is what makes this case so interesting, because I'm so used to, like, it's weird to see somebody filing something that isn't for the purpose of doing something in court.
Right.
It's like I can file a sanctions motion, and then I can tell people.com that I'm filing a sanctions motion, and then that serves its purpose. And it doesn't matter if I lose, because no one will care by then. And it's like, that's fascinating. I don't know.
Yeah. So, the amount of sanctions motions in this case will carry on in legal circles for all
keep
time.
in mind, they can still file them for a few years after too. So,
sure,
let's
just keep them coming.
Let's see. Okay, so Lively fails to allege an adverse employment action. So they're saying she does not allege she was terminated, demoted, deprived, or assert any act that may have blocked or interfered with a potential employment opportunity or any other materially adverse change to the terms of her employment.
The PGA, I was like, I just don't know how you look beyond the PGA letter.
Right.
To say I was adverse employment action because it severs causation, right?
Right.
And this is getting into the evidence and all that, so I'm conforming to the evidence now, but.
Well, she asked to, so we can.
Yeah. Girl, I'm just doing what you want me to do. I'm doing what you want as a woman. That's feminism. I'm doing a feminism.
Girl power.
But yeah, so and she can't allege it, right? Even in her complaint, she says no problem, second round.
Yeah.
No problems. I'm given editing, I'm given this, I'm given that. So for her to say, okay, well, the adverse employment action is the retaliation. You've pled facts that sever causation.
Right.
You've pled facts that show that you received favorable employment action, that nothing was wrong after you reported the alleged protected activity. And I'm going to call it that because I just don't know that 17-point letter can really be protected activity. Mm-hmm. So, I read this one and I was just like, that PGA letter is her worst nightmare, because how do you say it's because I reported my sexual harassment that they retaliated against me in the press? But in the meantime, they wrote me a favorable PGA credit letter. They allowed me to, I got final edit. I got this. I got that. Okay.
Yeah.
That all happened between protected activity and retaliation. So
right.
What are we doing here?
And you can see
what are we doing here?
What are we doing here is a great I mean, even in the oral arguments, I think they said the protected activity was not taking photos with him. And it's like, remember, the protected activity has to put the employer on notice that there is sexual harassment, that there's something that she's considering. So is it reasonable for them to think that the reason she's not taking photos is because of harassment, right? She's not taking his name off the poster because it's making a safe working environment for women. She's taking his name off the poster because by now it's her film.
Yeah.
And Colleen Hoover's got that, right? Where she's saying, I wouldn't want to stand next to him either if I had to see him take credit for the stuff that I did.
Right.
And it's like,
okay, Colleen, go color in your coloring book.
She just has thousands of coloring books if they got canceled, right?
And didn't Justin do there was something that he did in terms of the rights to the movie. There was something that he did in relation to the movie that pissed Blake off around that time. And then she said, I don't want to do promo with him. And then everybody else said, I don't want to do promo with him. And I can't remember what it is. I have Katie's timeline. I probably could look it up. But he made his own coloring book or like nail polish or something.
Was it the coffee table book?
Maybe it was. Yes, it was the coffee table book.
Yeah.
So that comes up and Blake is just spitting mad that he still owns the rights to this movie. And it's like, I'm not doing promo with him.
Yeah, that's true. I forgot. That coffee table book is very understudied in the lore of this whole film. So maybe we need to do a deep dive in. I'll do a deep dive into the coffee table book. But
should we buy it?
I don't think it ever got made. I think Colleen nixed it when there was some issue. Yeah. Justin
Baldoni and Jamie Heath. If you're listening, wink. We all know you pay me. Wink.
Oh yeah, absolutely. Jed.
If you could pay my student loans, that'd be great. Yeah, if you guys could let us see a copy of that book,
that would be great.
Do us a favor. It's feminism for you to give me what I want.
Right. Jed, if you're listening, yeah.
Hey buddy, hey.
Hey. How's Texas? Good luck on your appeal. I saw that it's starting to get filed. It's due on March 16th. I'm really excited for it.
Oh God, I cannot wait.
I know.
I hope the appellate court is like, yes, this goes through in Texas.
we're never going to be free of this case. American democracy will crumble, and Lively and Wallace will be suing each other over the ashes. Okay, so
Lively
okay.
fails to plead a causal link between her complaints of harassment and the alleged smear campaign, which is kind of just what we were getting at. She fails to plead temporal proximity between the allegedly protected activity and the commencement of the alleged smear campaign or retaliatory purpose. And that's what we were just going through.
Right.
The middle column is their arguments, right? Oh,
yeah,
it's
the
just
middle column
distilling.
was me. Yeah, trying to explain what the facts are that kind of substantiate that.
And so this is where she really drives home, like, let's look at the evidence in my motion for summary judgment. Yeah. And she relies quite a bit on her experts.
Yes.
For better or worse.
And I have a whole live that I did on the expert witnesses, but I was telling Britt earlier, it is a house of cards. Her damage expert is relying on her internet expert, and her internet expert is relying on another internet expert to talk about the causation piece. And the causation piece comes down to Melissa Nathan and Jennifer Abel's depositions, which we don't have access to, and the text messages from the New York Times article. So I don't want to say the New York Times text messages have been debunked. What I will say is some of these messages are things like Katie Case saying, we are seeing a shift on socials due to Jed. Katie Case, I can show you in her deposition where it says, I made that assumption because we hired Jed and I saw things shifting. I didn't call Jed and see what he was doing. I just assumed we were doing something.
I didn't call Jed and ask him how he knows Kirsty Flaw.
Right. I just assumed that we saw a shift on socials. I assumed it was Jed. And also, I think part of the lens here is she's working for TAG. She's going to tell you that TAG is the reason why things are going well. She's not going to be like, yeah, we're seeing a shift on socials, but I don't think it's anything to do with us. I think it's just a coincidence and you're paying us $15,000 a month for nothing.
Right. Could you imagine if I was telling my clients well, I don't actually think it's based on what I briefed that we won that motion.
Yeah.
It's really just because the judge thought I was pretty that day. Could you imagine that it wasn't due to my hard work?
No,
you're not paying me lots of money for nothing.
Right.
Of course you're going to take credit for it.
Yeah, of course you're going to be like, yes, the work that I do is valuable.
And what wasn't put in the New York Times
is the context.
As well as many text messages saying we do not want to smear Blake in the media.
Right.
We want to protect this movie. We want to protect the studio. We want to protect, of course, ourselves, right? But they are saying over and over, we do not want to smear the lead actress in our film. We would like one of our films to make us some money.
Yes. And it's obvious too that they're cherry picking the messages. I don't even know that they show the experts all the messages from what it sounds like. Because they didn't show them Katie's deposition. They just showed the message where she says Jed is doing stuff. And
they didn't give the Darvo expert all of the information. I can't imagine they gave any of the other experts all the information.
They didn't give the Darvo expert the PGA letter. And I'm like, well, I'm not an attorney, but I feel like I know how this is going to go.
Yeah.
So
yeah, some of the information she relies on, it's right, I would come to that conclusion too.
Yeah.
As many of us did when we saw Blake Lively's complaint.
Yeah.
And then we saw more evidence and we're like,
do you get clients? Sorry, I know this is kind of off topic, but do you get clients that just kind of don't understand this late in the game, that this is this is a two-person process?
What is a two-person process?
That the other person is going to get to present their side of the story.
Yeah, yes. I have many clients who along the way are so stuck in their narrative, right? This is what happened because this is what I've been telling myself, and this is what I've been telling you, and this is what you're telling me back to me. They get so stuck in that narrative that they think, oh, I'm not worried about what the judge will think because this is the truth. This is what happened.
Okay.
And whether or not that is the truth, I'm like, right. But also this person has an entirely different narrative and they do have some facts that work in their favor. So,
right. Okay. I just wondered.
It happens a lot in family law.
Right. Okay.
It happens a lot in family law. It is imagine your worst breakup. Not you, everyone else. Um, imagine your worst breakup, and then imagine you have the courts involved with it, right?
God,
And the
yeah.
narrative you told yourself, and you tell all your friends, and you tell your mom and dad as to why you broke up with this person. And now you think, well, I've said it so many times, that's the truth. You miss the huge gaps, right? Where you came home
Right.
and you were like, shut the fuck up before I've had a beer, right? Or whatever.
Whatever it is that you did, right?
Exactly.
That was
Like, people forget that they poke and prod, and it's a whole dynamic. And that's not to say one person is right or wrong, but it's just you miss the gaps that somebody else might hear that story and pick up on and go, you missed some stuff that I think is really important.
right. It's a two-person. It's a two-party process, right? It's you go back and forth talking about what you think happened. It's just
Right.
I'm very used to, yeah. I've heard before, criminal law is bad people at their best, and family law is good people at their worst.
Yeah.
So
Yeah.
I feel like we're on. I've never done anything with family law. I'm used to seeing people that are just have done horrible things, but they're so nice. they're so chill. They're like, yeah.
It is, people are, a lot of lawyers will be like, I don't know how people do family law. And I'm relatively new to it. I just added it to my civil practice. So maybe I'll burn out here in the next year, but it is kind of rewarding to work with people who have suffered domestic violence situations and to help give them the tools to renegotiate a relationship with their abuser because they have kids with them.
Right.
Right. And as difficult as it is and as shitty as people can be in these scenarios, it's nice to just constantly be saying, we're going to keep our side of the street clean. We're going to keep our head above the fray. We're not going to do this unethical shit. We're not going to drag them in the mud. I'm going to give opposing counsel, grace, and I'm going to give them breaks, and I'm going to try and work with them in as many ways as I possibly can without sacrificing the case, obviously. But
right. But just to kind of leave it better than you found it.
Ideally.
Right.
And if nothing else, I guess I'll get paid.
Yeah. Speaking of which, Jed, my
Venmo's in my bio.
Right. Buy me a coffee, or like 10,000 coffees. Okay. So basically, did she file a timely complaint and obtained a right to sue letter? I feel like we still have questions about some of this stuff. So she filed a CRD complaint. She didn't include it ends with us. And
I thought her complaint about joint employer was an interesting one. That's not one that I've really heard much. That's not a complaint I have ever made, joint employer. I've made pierce the corporate veil, right? Because it ends with us as a subsidiary of Wayfarer Productions. And what she's saying is the issue is she didn't sue or bring a complaint against It Ends With Us LLC, which is who contracted her out, right? She sued Wayfarer and she claimed Wayfarer did this. And she's saying they're actually just one entity, which I don't see going very far as joint employer, because now you are unraveling all of the LLC work that happens in Hollywood.
Right. Like
every major production is a subsidiary of the major company. I mean, even Sony's distribution company is a subsidiary of Sony, right? Like everything gets factioned off into these little LLCs. And if the judge goes, yeah, joint employer.
I mean, to give you an idea, there's another case where this has come up with Alec Baldwin and him killing Helena Hutchins on the set of Rust. The insurance claim was capped at $6 million because that was the amount that Rust LLC had.
Yeah.
So it's like, if you pierce that and you go for the production company, think of, I'm not sure who was the ultimate producer there, but imagine if like they could pierce that, then it's like you have now a wrongful death suit with a potentially billions of dollar company.
Right.
And they've created this LLC to specifically insulate themselves now, which is the purpose of an LLC. It's why she has Blakel LLC.
Right.
So, yeah, that's
so if she pulls a Donald Trump and stops paying her employees, you can only sue Blakel. You can't sue, Betty Brown or whatever other LLCs or her personally.
Right. So,
I thought it was a clever argument. I don't see it holding weight. And I think this is again where Lyman's maybe connections to Hollywood may work in their favor, but it's so common in every area of life. People with money have LLCs to shield themselves from liability. And for him to just be like, well, they're a joint employer without any corporate veil evidence, just sure. They both have some of the same officers. So that's enough for me. Like
I think he's really trying to avoid setting any kind of precedent with anything in this case.
I agree.
So, all right. Okay, so Lively's defamation claims with Brian Friedman, she has an entire expert witness that is just talking about these at-issue statements. I thought this was like a fun little additional claim that she was bringing just to make Brian Friedman look bad. This is very, very central, you guys. Now, this is very fucking central to her whole thing.
And not to name that who shall not be named, but I think she looked at the Amber Heard case because Amber Heard was successful on this claim and thought this is a winner. And to be honest, a couple of those statements were made before litigation. Now they had hired Brian Friedman as their counsel.
Right.
So is he doing this in the course of litigation? I think that's an interesting question. I think it's bullshit to drag another lawyer into this the way they have. And may they know that pain karmically in their next case.
Right. or in the malpractice lawsuit for this case.
Yeah.
And I do want to remind people, she would still have to prove that those statements were made with malice. So this is just getting the claim in the door. Do you think it's wise to go ahead with this claim? Because this opens the door for Friedman to say, here's any and all information that makes me think that you're lying, which means that, let's say some of these sexual harassment claims get dismissed. We're not going to be talking about some of this, but now defamation is now an avenue for them to say, and we're just going through the lens of, did you lie? We're not even really looking at the harassment question, right?
Well, and now he gets to pull in, we just mentioned how character evidence isn't allowed. One of the exceptions is that when there are reputational damages or when we're talking about something like this.
Right.
So he gets to say, I think you're a liar because you, on every set you've ever been on, recruit your fellow colleagues, your fellow actors to hate on somebody else based on lies you tell them. I think you're a liar because you were texting my client, oh my God, oh, sugary sweet. And then texting your best friend what a doofus and a clown he is. I think you're a liar because, right? And he can go on and on and on. And it can be all character stuff, but it's valid for his defense because that leads into the mindset that I think this person is a liar. And here's why.
He gets to prove that he's not acting with malice.
Right. I'm not acting with malice. And what I said was true.
Yeah. So I just think this is a funny claim. I am also shocked that she has an entire expert just for this.
I love that for her.
And it's because of that graph. I'm telling you.
I love that for her.
That graph. Okay, so there's the litigation privilege, which we've kind of already talked about.
I did, just so everyone knows, I did get to argue litigation privilege in one of my cases very recently. They said the allegations made against the other party were defamation. It's a domestic violence case. I mentioned it in my allegations, and they said, this is defamation. And I was like, litigation privilege, suckers.
Has this case given you any insight into your own cases?
Yeah, a little bit. I feel like every time I watch a celebrity case, a little part of me is like, okay, yeah, I could do that. Or that's a good procedural argument. Or, oh, I've never thought about that. So I don't know. I'm only 7 years in. I'll be 7 years in June is when I was licensed. And I still feel new all the time.
Yeah, you're a baby lawyer.
I'm not quite a baby lawyer. That's usually for the under 5-year lawyers, but
you're a teenage lawyer.
I am a teenage lawyer for sure. I'm so thankful that I have people that I work with that I can bounce ideas off of.
Yeah. Let's see. Okay, so what did you think of her civil conspiracy claim? Okay.
Yeah, I mean...
So, I mean, if you want to look at Wayfarer's argument, the biggest argument that they're making is an element of a tort. So I have a video on my profile, Torts in 4 minutes, but basically you need to establish that there's a duty of care from the defendant to the plaintiff, that there's a breach of the duty of care.
She
that the
said
breach
duty.
That the breach is the proximate cause and actual cause of the damages, and then that there's damages, right? Yeah. So the question is, what do they owe her? What is the relationship between Lively and Wallace, or Lively and Sarowitz, or whatever? It's not, there's certain torts like defamation where there's an assumption that you have like an obligation to not lie about people, right?
Right.
But civil conspiracy is kind of like...
So the reason I hedge is for a couple of reasons. Mm-hmm. One, the smear campaign isn't actually a smear campaign, because everything that was being smeared were true. We were discussing her racism. We were discussing her poor treatment of prior colleagues on prior workplaces, her poor treatment of Kirsty Flott, right? So it's like, none of this is untrue, which is typically what a smear campaign is.
Right.
So for me to believe that there was a civil conspiracy by Jen Abel, Tag, and Jed Wallace, they had no reason to know about, even if we take the sexual harassment claims as true, right? Let's say he did sexually harass her, okay? Say there is protected activity, and let's say all of that caused them to retaliate. I don't buy any of that, but let's just, for the sake of this argument, say, oh, that's true. We have no evidence that any of those people knew about any of that. We have no evidence that any of these people think that any of these videos that are being spread are false. No dialogue about Blake is false. And this is a relatively new area of law, or it's a new question of law.
Right.
Can a smear campaign be retaliation? So in no world did they have any reason to think anything they were doing was illegal.
Right.
And like you said, there's no duty of care to Blake. But even if they're assisting these people as agents, right? Because Justin and Jamie do have a duty of care to her.
Yes. Yeah.
Wayfarer Productions maybe arguably does.
Right.
Steve Sarowitz does, right? Because he's a producer on the film. They all have a duty of care. So the other people are acting as agents of these people. I think we can make an argument to connect the two, right?
Yeah.
That the duty of care actually comes from the principle that they're representing. Fine. Everything, again, is true, right?
Right.
This is not defamation, and that's why she doesn't make defamation claims here. This is why she's saying this is workplace retaliation for turning in harassment. Because otherwise, there is no actual malice, and these claims aren't defamatory because we're just talking about things Blake Lively did.
I do want to point something out, just because you did make this comment that I think is interesting. You can't sue an individual for retaliation. So Heath, Baldoni, and Sarowitz are not on the retaliation.
Right.
So this is kind of the only thing linking them to the retaliation, is the civil conspiracy and the false light claims. So if that gets dismissed, if that civil conspiracy goes away, yeah, you've got the employment claim against Wayfarer, but then that could even go away because you should have sued. It ends with us. It's a house of cards.
Yeah. And that's another question of law. Are you allowed to amend your CRD complaint? On one hand, I want to say that the rule should be yes.
Yeah. Yeah.
On the other hand, these are sophisticated lawyers and these are sophisticated parties with lots and lots of money. And the fact that they missed that is...
I guess the only thing is, though, are we saying that, like, even if there was a typo, like, what if somebody knew it was the wrong, like, let's say you have an employer and they're based in multiple states, right? Yeah. Like, I work for Van Zandt Incorporated, and there's a Delaware one, a New York one, and a California one, and I need to sue them. And I accidentally put the Delaware organization on a CRD complaint.
That happened in a lawsuit, and I can't remember. They sued Universal
Mm-hmm.
and they served Universal, but they didn't serve the right Universal. I want to say it was the copyright infringement case against Taylor Swift for the Shake It Off lyrics. The writers of 3LW sued Taylor Swift, saying her song Shake It Off is way too similar to our song, Play Is Gonna Play. And they make some really compelling arguments to get there, right?
Mm-hmm.
They have a structure of 4 characters, a play of plays, a ball of balls, a shot call of calls, and she has, heartbreaker breaks, whatever.
Mm-hmm.
So they're saying it's way too similar. And oh, by the way, we used playa or player in a way that hadn't been used in pop culture before, and she stole that from us as well. Okay. Really interesting case. But they sued Taylor Swift and they sue Universal, and I'm 90% sure it was this case. And they sued the wrong Universal. And later they asked to be able to amend their complaint, but they asked like after discovery.
Ooh, okay.
Like, right?
Yeah.
And everybody said the defendant sat on it like, we're not going to tip you off to this.
Obviously, yeah.
So,
did they say no?
They ended up settling out of court.
Oh, we should cover that case.
I would love to cover that
Let's
case.
cover that case. But also, I mean, I will say it's different though, because they caught it within a couple of weeks. Like, I'm thinking of it through the lens of like, what do I want employees that are not empowered to be able to do, right? It's like, I feel like this is a harmless error.
I agree. Like, and I don't want the rule to be, because a lot of employees will end up bringing these claims on their own.
Yeah.
Or they'll start the process on their own because you have a very short clock.
Exactly, yeah.
And I don't want non-sophisticated parties to be stuck under very sophisticated party rules.
Yeah. I feel like that should not be the bar here, personally.
I agree.
Like, it's funny. It's kind of funny to see it happen with very, very well-paid attorneys. But yeah, I think this is like, just let it go.
But it's the problem too with all those subsidiaries and with different companies, right? You have Universal Inc. and you have Universal Publishing and you have,
right.
Yeah, you have all these very similarly named companies, and it would be very easy to mix them up.
Yeah, I should be able to sue the right, I shouldn't have to find the right Van Zandt to sue Van Zandt.
Exactly.
So let's see. Okay, and then I kind of had gone through her responses, but I think we mostly covered that. Was there anything?
The extraterritorial application, I think, is a really interesting question. I think some of this stuff gets dismissed maybe on that issue, although I could really see it being she's an independent contractor, so these laws can't apply to her.
I think one nice thing about Lyman from reading his opinions is that if he thinks both of those things are the case, he'll say it. Right. And I expect that if he thinks the facts don't substantiate a sexual harassment claim, like on the facts for the motion for summary judgment, he'll also say that. Yeah. I'm expecting this to be a 300-page opinion.
Oh, easily.
Yeah.
Because how many, the Wayfarer dismissal was what, 60?
Yeah.
Ish?
Yeah. I think this is going to be in the hundreds, and I think longer. He's so thorough. Let's see. Okay, so there's that estoppel argument, which we talked about, not getting to argue California. There's all the California stuff. Let's see. Yeah, I mean, I don't think that. I did think this was interesting about like whether conduct amounted to sexual harassment or retaliation reflects an unactionable opinion. There was a case, Coleman v. Grand, that both cases have cited, and it was funny because Wayfarer was originally citing it and they were on Coleman's side, and then they cited it later and they were on Grand's side about whether or not it's an opinion question if someone says they were sexually harassed. So Lively had said, I was sexually harassed, and they said, that's defamatory. And she said, no, it's not. It's an opinion. And they're like, no, it's not. Coleman v. Grand. And now she's saying, hey, you said this is sexual harassment. And they said, that's an opinion. And I'm like, hey, guys, is it an opinion or not? So they have kind of used it both ways. They both sides have played it both ways.
Right.
It's your opinion statement. I did think that was funny.
I mean, whatever works in the moment, right? Fuck your credibility long term.
I mean, I think I'm probably the only person who was like, you just cited the other party in that same case.
Wait a minute. I read that case.
I read that case. I also did like, I do like when they're
hang
citing
on one
themselves.
second.
Sure.
So the garage is my man cave, woman cave, and sometimes I have to tell my mom she's not allowed to park in here.
You can't park. You can't park because I'm a white guy with a podcast now.
Can't sit with us.
I'm in my podcasting man cave.
Bring me some Cheetos.
Let's see.
Man,
so
when we put it all like that, I feel like a loser.
We're just two guys with a podcast.
Stop giving me microphones.
There was this guy, a friend of mine, Tyler, was saying like, I'm a bald white man. It's actually like a crime that I don't have a podcast yet. And we don't have enough white men with podcasts. So let's see. Yeah, I do like when they cite themselves. She kind of cited her own the case before, and it's a good reminder that some of this could be precedential later on.
I do find it interesting when she's like, "Hey, judge, remember when you said?" And that is actually very smart lawyering to be like, "Hey, let me point you to the record in this case."
It's like telling the teacher, "That's not what you said to Timmy last week," you know?
Yeah, exactly.
And so it does say like, at the time of the December 21st statement, the only active proceeding was the CRD complaint. Friedman's statement doesn't expressly reference the CRD complaint, and it didn't necessarily, as a self-contained sentence, give any idea that it was referencing the CRD complaint as opposed to the article itself. It's kind of funny because this is, again, having it both ways. The New York Times is able to defend itself saying that we have the fair report privilege because it's based on the litigation. But then when Friedman references the article, well, it's not based on the litigation. You were referencing an article.
Right.
So,
right.
There's a lot of having it both ways.
We're circling a drain a little bit here.
A little bit, yeah.
The defamation claim against Friedman, I genuinely want to go through. I think it would be, I'm so sorry, Brian Friedman, if you're out there. I can't imagine you're listening to this, but I don't know why I use that tone. We're the coolest.
We're the coolest. And he knew Katie. Yeah.
Did he, or was he just like, oh, friendly person? Yeah, thanks.
No, I think he actually said something like he said like, oh, hi, I know, like something like he recognized.
Oh, we're watching you too, or something.
Yeah. So, and we know Jed is watching this and his bots.
I wasn't sure if that was actually what he said, or if that was just what the Pro Lively Reddit wanted us to believe.
Well, she's Pro Lively now, right? Have you seen that? She's Pro Lively now. She's actually been paid to switch sides.
Guys, just if you feel like someone no longer is serving you content you want, I beg, block and move on.
If they're not serving you content you want and you're a woman, that's not feminism.
That is not feminism. Katie, I'm so sorry if you're out there. I didn't even watch the live. I just was like, oh, okay. Poor girl.
Poor Katie. But we
we do. Making content is it's difficult, you guys. It's having everybody have an opinion about you is a very interesting experience.
I mean, ask Blake, right?
I get why she was very upset. I just don't get why she sued somebody else about it.
Right.
And I mean, I get why she was upset about the backlash she was getting online, not about, just so we're clear, please don't cancel me. I didn't flip to Blake's side.
I haven't yet, but I can be bought. I continue to reiterate that I can be bought. Right. I'm expensive, but I'm not free, but I can still,
I can be bought too, but I promise you I will breach that contract so fast.
Blake, I will make a Blake Brown video. I will tell people that this hair is entirely due to your products for the right price.
I will tell people this hair is entirely due to your products, and I am balding from perimenopause. So do what you want with that.
It's part of the ongoing smear campaign.
Yeah. Okay. Let's see. Should we move on to the motion for summary
Yes.
judgment?
I have it pulled up.
Now that we've lost everyone, they're like, oh, they're pro Blake and
They're pro Blake.
they're defending pro Blake people. No, I don't love Brian Friedman's like thing.
Yeah.
I practice with a lot of men like Brian Friedman, and I know it's cute because he's on Justin's side. It's not cute when he's your opposing counsel and he's being a dick all the time.
Yeah. And he was a dick in the deposition.
He was a dick in the deposition. His media presence is very like swing it around, flop it on the table. Like it's just not my thing.
Yeah. It's you kind of, it's one of those things where he's insufferable, but you kind of like to see somebody be that person, especially when they have a client that is not willing or able to be that person.
Right.
You know,
when you have Justin that's like, okay, so I gave you everything. I gave you the director credit. I gave you the movie. I gave you the editing. Are we still friends?
Right.
Like,
and then Brian's like, I'm going to be a fucking asshole. Like, just,
yeah.
You know, and then you gotta kind of have Jamie. I still think Jamie's their best witness. I think Jamie's their most like
I agree.
solid. So,
Yeah.
All right. So let's see. Motion for summary judgment. I kind of went into an explanation on this. I'm so glad we're getting to use this. I spent like 6 hours on these documents.
They were very thorough. I spent quite a bit of time going through them, and I was like, damn, you were.
I read it so y'all don't have to, but okay, so the big thing, okay, so sexual harassment. So I just went through all of her claims. Sexual harassment, this isn't a civility code. We don't have severe enough behavior. So let's see. And then I see yeah.
And we've talked about this. I think that based on what's here, there's a good chance at dismissal at summary judgment. There's just not enough. It is not pervasive or severe to a reasonable person standard. You can feel how you want to feel about a director saying your costume is sexy. You can feel like he wasn't even saying that as a director. He was saying it as an individual to Blake Lively herself. It's still based on what the law tells us. It is so nominal compared to the bar that has been set.
Right.
And that's a conversation we should have as a society, but let's deal with all this Epstein stuff, put a pin in this and come back.
Right. We unfortunately we have to deal with the law as it is.
Right.
You know.
And in a creative workplace, and I think the judge really drove this home, you don't want to stifle that creativity by making people afraid of what they can and cannot say. You don't want people to feel, now directors go too far all the time. That's sort of like a known thing about Hollywood. I'm not really defending that, but you also don't want someone to be afraid to use the word sexy.
Right. And I mean, Lyman brought in, you know, if we draw the line at consent and we say that consent issues go to a jury, what happens is we get rid of intimacy coordinators and we get rid of nudity writers. We get rid of these safeguards that we have put in place because now everything becomes a jury and the jury becomes that safeguard. And then the effect is, how much can people really afford to go to court over everything?
Right.
You know, that's actually, I think, the strongest argument for why the standards are where they are, because you want to incentivize HR departments to be handling this in the moment and at the job, you know?
Yeah. By the time it gets here, you're breaking banks.
Right.
And for a lot of people, they could not afford to go this far.
Yeah. And I mean, I've even thought of this, just like, I do think some people that are saying that they find this to be egregious behavior, I think they're being disingenuous, right? I'm just thinking of jobs that I've had in the past where it's like, if I had an HR complaint or a lawsuit every time somebody said, your English is really good, or how long have you been in the US, or I'm not going to call you your real name, I'm going to give you a nickname. It's like you'd never be done. And it's like, I don't think people realize, like, a lot of workplaces, you just have to kind of go, can I address this in the moment? Can we have a conversation and move past it?
I was a bartender.
Yeah.
We said vile things to one another.
Yes.
We had a contest at one point to see who could get the other person to break by grossing them out.
Right.
Like, again, not defensible workplace behavior.
Right.
But we're working with alcohol and we're degenerates.
Right. I mean, I worked for a couple of years at a suicide hotline. And there's dark humor in that kind of an industry. And it's like, you do want to be able, you know, it's not so much that it's always okay to do this kind of thing, but you want people to be able to work this out. Right. You know, you want them to be able to say, this is what I'm comfortable with. This is where I'm close. What, you know, like make friends at work, but then also have a professional environment, and for everybody to be able to kind of negotiate their own limits.
Agreed. And it really speaks to I think a lot of women out there do find this really egregious because they're the kind of women who believe the myth that they can't speak up for themselves. Well, I've been told I can't speak up for myself, so I'm not going to. Right. And it's like, it is your job to protect your uncomfortable feelings in the moment, just like Jenny Slate did.
Yes. Yeah.
Jenny Slate addressed it. She said, we don't talk like that. I am not sexy to you.
Yeah.
I don't care. I don't care the excuses. No, we don't do that. And he was like, great, stop. I'll stop.
And he did, you know, and this is one of the interesting things with her being kind of one of these 9 victims, because I do think that she's actually a terrible witness for Blake. She's saying, I identified the issue, I nipped it in the bud, he was fine, and it went back to normal. And as I sit here, I don't have any further issues.
Right.
And, you know, I think that's obviously then the cross-examination question is, so why were you texting everyone saying this is the worst work environment you've ever been on?
Right.
If it wasn't for these reasons, what were the other reasons, right?
Right.
But yeah, it's just,
yeah, it is up to us in the moment. I mean, I had someone make a grape, I don't know what we're allowed to say on YouTube, a grape joke to me. And I just looked him dead in the eyes and I was like, I need you to explain why that's funny.
Yeah.
Dead ass. And he just was like, you terrify me, and ran away. And I was like,
and it's like, good. That's, you know, but the reality is too, like an HR department, they're going to say, well, what did you do when you had what happened when you had the conversation? Right. Because you need to be able to nip this in the bud. And sometimes an HR can be there to facilitate that, obviously, but
sure. This is my direct manager. He's been known to stop giving other people, like, fine. There are scenarios where, of course, you're going to be like, hey, they made a grape joke. I don't feel comfortable addressing it.
Right.
Can you just tell them to not? Yeah.
So do you think too, if this, I mean, I know you said it would get dismissed, but one thing I'm stuck on is a lot of the sexual harassment is going to be very like known to the jury. They're going to have ideas of HR and processes and, you know.
Yeah. I mean, I think there's a strong chance this gets dismissed. Not only because it doesn't rise to the standard, but we've got some independent contractor employee issues going on. So I think at least it gets narrowly, you know, tailored down. But yeah, I don't know that a jury looks at this and goes, because as much as people you are encouraged to see this case through the plaintiff's eyes. This is not about you and what you would do. You don't work on a movie set, right? You have to imagine what it's like to work on a movie set, as Blake Lively does, right? This isn't about what you would do in an office, because these people don't work in an office. They work on a movie set and they're filming graphic scenes, and they are, you know, coming into contact with these really graphic topics. Right. So we have to put ourselves in Blake's position. Now, does Blake's subjective reality meet a reasonable reality, right? Is her subjective idea that she's being harassed come to a reasonable standard? And I think that's where the jury goes, no.
Right.
As much as you want to give them this whole song and dance of put yourself in Blake Lively's shoes, they're still going to go, I wouldn't even ever report that comment.
Right.
I think some of them are going to be like, she calls herself sexy. Like, why?
What? Yeah.
If I was out here calling myself sexy and then my boss was like, oh, that looks sexy on you, how are you going to turn around and report that? So, yeah, that was... I went into the read factors. So, something that I noticed, and down here towards the bottom of, I think, that first page, what did I do?
Maybe I shouldn't have done that. Okay.
What did you do? So it goes through the read factors, and then down below,
you've got the read factors here, and then
they quote case law, and they say control is the most important factor, and is alone reason to deny summary judgment. These sort of spliced up quotes are all over the opposition. And I went and checked a couple of them, and they are incredibly disingenuous as to how they are quoting things. And almost 100% of the time where you see these spliced up quotes, it's spliced up like that for a reason.
Oh, I hate when lawyers do. I hate this so much when lawyers do that.
Legal writing credibility 101. Throw in the whole quote.
Yeah.
Emphasize what you think is important. Now, if it's 100-word quote, obviously you would do like a sentence here, ... a sentence here, or
right,
argue in between and then do a sentence later.
So you're saying that in lively summary judgment, they said control is the most important factor and is alone a reason to deny summary judgment. And then what is the actual full?
The most important factor in determining the existence of an employment relationship is that control or right of control by the employer, which characterizes the relation of employer and employee and differentiates the employee or servant from the independent contractor. It's close, but it is not the same thing.
Right.
Right? And so right of control is huge here.
Right.
Right? Because they lost their right of control.
They lost the right of control.
And
I hate when they do. I hate when lawyers do that.
Right. So, but if you notice all over her motion for summary judgment, they have spliced quotes like that, where it's like, word, a little bit of argument, the rest of the sentence, and then they quote the case law, and you're like, that's not what the case law said, though.
Yeah.
Most of the fun
cherry picking things and taking them out of context and only giving people part of the information. In this case, I never thought I'd see that. That's so weird that they would do that.
Yeah, I mean, that kind of credibility, it just erodes at the credibility of the entire case, right? Because if you have to misquote the case law, then the law isn't really on your side. And if you have to misquote the facts, then the facts are not really on your side. And if you're going to do that a few times, I'm going to think you're a liar.
Right.
Or I'm going to think that your client doesn't have a case and that you're just pounding the table.
I mean, yeah.
We've got retaliation. The signed 17-point agreement, I think, is her best bet here, but I can't remember if we discussed this over the phone or on live, but something really important to point out, you can agree to things in contracts that maybe the law wouldn't give you relief for.
Right.
Within a certain amount of bounds, right?
Right.
It depends, but generally speaking, they don't get to redefine retaliation.
Right. Right.
And bring a retaliation claim. And I think you said that very succinctly the other day, right?
Yeah. I said, like, we can't make a contract where if you don't show up to film an episode of the podcast, I can sue you for wrongful death. If I want to sue for wrongful death, I have to meet the requirements of wrongful death. I have to show that a death occurred and that you were responsible.
The courts are beholden to the law.
Right. And this is kind of a breach of contract claim cannot be duplicative of a tort. You have to pick one argument or the other. Now, she's arguing in the alternative in her opposition for the motion for summary judgment. So she might be able to argue retaliation or as an alternative argument, this breach of contract. But this contract doesn't make it a retaliation. It's not redefining retaliation so that now she doesn't have to prove all the elements of retaliation. She still has to prove protected activity, adverse action, and the causation.
Right. I think that if this is a valid and binding contract, and the question is, this is a rider to a contract that is unsigned, that was still in negotiations even after they enter into this. So, but if this is a valid contract, now we have contract claims for breach of contract under what we agreed is retaliation.
Right.
So I would love for that to go forward. That would be fun.
Lyman, I don't know if you saw what Lyman said about the 17-point thing, because they are suing kind of for breach of contract. And he said, what was the consideration for the 17-point agreement? And they said that she's not bringing a complaint. And he kind of goes, we're here.
Yeah.
And they're
Yeah.
like, no, an HR complaint. And it's kind of like, well, does that include a CRD complaint? Does that mean
Also,
you've
then
waived a CRD complaint?
does that mean that you waived protected activity?
Right.
Because if you're saying the consideration is I'm not going to bring an HR complaint, that's the protected activity.
Right.
I'm really sorry, but saying I'm not going to promote this movie with you isn't.
Right. So it's like the consideration, because initially they said, well, the consideration was doing the film. And he said she is assigned offer letter, not even the ALA, just the offer letter
Yeah.
is that she's doing the film. And so that's another contract law thing. You can't have a performance of a contract be something you've agreed to in another contract. You can't
Right.
just, so you have to have something kind of new.
It has to be
And-
new consideration. I made
Yeah.
a video about that very early on of I don't think this is a valid enforceable contract because there is no consideration.
Right.
And
Unless
to say I'm not going to do something
Mhm.
isn't great consideration, right? Because now you've teed them up nicely for a duress defense. So now they get to say, well, it's duress because she's saying that she's going to make all these complaints about things that we don't think happened. And she's going to hold up the movie and she's not going to promote the movie. And, you know, all these things she's contractually required to do. That's extortion.
Right. Right. And it's just, but the other thing too is like, okay, so she says I'm waiving my right to an HR complaint, but I'm still suing for retaliation. And mind-bogglingly enough, failure to investigate.
Right.
Failure to investigate something that you explicitly waived with the help of an attorney in an email. And I want to, the other part here we haven't kind of gotten into that is Sony's lawyers and Wayfarer's lawyers both looked at this document and thought it was fine.
Right.
So it's not like this was some unofficial thing and nobody knew what they were doing. She had an attorney, Sony had attorneys, Wayfarer had attorneys.
Well, and notably, you know, kind of diving right into whether the 17-point agreement is protected activity. Mm-hmm. Notably, it says no more making comments about people's bodies. But it doesn't really say when that happened.
Right.
Right? So it's making very vague allegations about stuff. She has filled in the blanks later.
Right.
But can that be protected activity? If you go to your boss and say, I don't want anyone to be able to say that I'm sexy.
Is that the same thing as saying that it's already happened on a particular day, right? And the other part is, again, what if it did happen, but you settled it with that person? Like, what if Jenny Slate says, I don't ever want Justin commenting on my body again? She's been very explicit that she settled the issue with him when it did happen. So it doesn't mean she's saying anything else is happening.
Right.
So it's like, there's not much for an HR person to go on if they're just looking at the 17-point agreement, and you've got her lawyer saying she doesn't want to go any further.
Right.
So let's see.
I kind of put some of the quotes of just her arguments.
90 presumption of retaliation within 90 days, and we're looking at kind of 8 months.
Yeah.
If we want to use the January 4th meeting, which
I think is probably her best bet. There's no way a judge buys into the not promoting the movie. I understand why they did that.
Oh, yeah.
Because then they can say there's a genuine issue of material fact.
Right.
Because we're saying this was the protected activity, right?
Right.
But I don't know that anyone buys that.
I did discuss with Dan the spoliation stuff. I saw that evidence was destroyed. Because evidence spoliation is something we come up with all the time with criminal stuff, and I couldn't. For the 90th time, it was one of those things where they're like, "You're not explaining it correctly," and I'm like, "I need you guys to understand."
No, I am.
I am doing my best. They're not explaining it well because they don't have anything. But
yeah, and that I think is her best bet here with retaliation. There was retaliation. I can't prove it because it was in these chats that disappeared.
Right.
I think those companies have a vested interest in that not being the outcome. Signal, I think, doesn't want that to be the outcome, because if you can say somebody's destroying evidence merely by the platform they're using.
Right.
That's a tough precedent, and people may just not want to use that platform at all.
Just
given
using
the
Signal
risk.
as some of someone, I don't know this for sure. I heard this from somebody looking at his messages, but somebody said some of Ryan's text messages that were submitted were Signal chats.
Oh, I love that for him.
Yeah. I mean, and they have that email from Stephanie Jones saying, let's use Signal because it's safer.
Right.
So
I did love that in the depositions where they were like, when did you start using Signal? And Jen Abel was like, Stephanie told me to use it.
mm-hmm.
I was like, ooh, tea.
I think Katie too, Katie Case said she spoke with Jed over Signal. She said he never took me individually over Signal. It was just if we talk to Jed, we have to use Signal. Right. Which I think does validate this idea that like she's not doing it to hide anything. It's just this is the platform he uses.
Right.
You know. So
I mean, I get it. You gotta text me. If you message me on TikTok, it may be a little while before I get back to you.
Yeah. Let's see.
Yeah, I think, in discussing the retaliation, another thing we've talked about quite a bit is a falsely inflated bot campaign, content that's falsely inflated. You can trace that.
Yeah.
And we have seen in other lawsuits the criteria people have used to determine things are bots.
Right.
VPNs that move around, right? So they're in one country 10 minutes ago, they're all the way across the world another 10 minutes ago. VPNs in places in the world where nobody lives, right? So there are ways to determine things that are bots. But Blake was more interested in getting the personal information of Ken's, who had one YouTube follower, than she was about the people who actually liked the videos that were the smear campaign.
Every plastic gem on that spatula is an individual bot going out and smearing Blake Lively.
I love that Ken's is like, oh, you've made an enemy of me. And it's funny because like, okay, now you've platformed that person.
Right.
Somebody explain the Streisand effect to Blake Lively. She really needs to learn about it.
They're going to start calling it the Lively effect here pretty shortly.
I
think this is interesting. This Wayfarer defendants on the right-hand side.
The Wayfarer defendants' effort to characterize Lively's claims as petty slights. That bit.
Yeah.
Cannot be squared with their express agreements in January 2024 that any changes in attitude, sarcasm, marginalization, or other negative behavior as a result of these requests is retaliatory and unacceptable. I mean, again, we have a breach of contract claim.
Yeah. I just did think it was kind of an interesting point that they did sign something saying this is bad if we respond. There's that duress argument, like you said. I just thought it was kind of like, oh, okay, yeah.
Sure. I mean, yeah, we signed this. We knew that we anticipated it would be enforceable. In fact, our lawyer said because all of these things need to be happening on set anyway, right? So,
right. Yeah.
I mean, the question then becomes, what is sarcasm? What are changes in attitude?
Right.
Am I not actually allowed to respond to anything? I think changes in attitude are just her mad that he cries.
I think the other thing is this goes to a control thing. Imagine saying you're an unempowered employee, but having your boss sign something that says they won't change their attitude towards you.
Right.
Like,
or be sarcastic, and then I get to be the arbiter of what that is.
Right. I mean, this is kind of wild.
It flips the power dynamic on its head for sure.
So this is one of those things that if they read this to a jury, I think the jury is going to be like, why are we here?
Yeah.
Are we here because they were sarcastic?
Right. He made one sarcastic comment that seems kind of fine.
Are they going to be like, Blake Lively is ready to direct? And they're going to be like, this was retaliatory.
As far as besmirching her reputation, they argue the statements to Colleen, refusing to support her PGA letter, which they have eventually ended up doing.
Yeah.
So I thought refusing to support her PGA letter was a crazy argument to make because it's a remarkable document.
It's a remarkable document. And also, like, what she's just saying, they didn't hop too fast enough.
Right.
It's not saying they didn't do it.
Right. Disparaging her to Sony, which I thought was funny because Sony's internal communications are also like, she's a terrorist.
They're much worse. Was Sony disparaging her to them, you know?
Yeah. Planning and implementing a press and social media campaign to bury her, and Baldoni sticking to his original marketing plan, which I thought was interesting, which also makes me think that issue that Isabella Ferrer had in her deposition, where she was like, well, he went off script for the marketing plan, and that was Wayfarer and Sony's marketing plan. And he did it to make us look bad, right? They're saying he departed from the film's agreed upon marketing plan, knowing in real time it would harm Lively and the other cast members. One, how does he know that?
Right.
This does not seem like a man who spends much time online. He's not chronically online like the rest of us, right? Two, it's Blake's marketing plan.
Right.
The fact that they're trying to throw Sony under the bus is crazy. But three, like, that was his marketing plan all along. I don't know. It just feels so far afield of he's disparaging them with this nefarious plot to, I'm going to talk about the real issues and I'm going to make them look bad and the internet's going to hate it. Nobody made Blake Lively be insensitive.
Well, and I was actually just going to say, like, devil's advocate, do you think it's possible that there is some sort of Baha'i mind control that makes her make jokes about location sharing in interviews? And, you know, we haven't really seen anything maybe she's got an expert that can talk about the Baha'i mind control.
Yeah. You know what? That's in one of the reply expert reports.
Yeah.
It's got to be. I just thought that was a crazy, but that to me makes me feel like that all was fed to Isabel Ferrer.
Probably.
We need you to say this, because I don't think Isabel Ferrer is coming up with that on her own. And then they're also arguing it in a motion for summary judgment. I think they needed somebody to say it.
Yeah,
that wasn't Blake.
She even says in her deposition, I think the studio I'm talking about is Wayfarer. I mean, I know she's saying this because she's like reading her text message. So she's talking about, like, when I sent this text message, this is what I thought at the time. But it's like, she was very in the dark in the moment about why things were happening. And I mean, they do kind of say, like, part of the or at least Isabella says, she thought that even though they were no longer saying his name in interviews, so just saying the director or my director, and they're mocking him in the interviews and he's not invited to the premiere, he should have gone public and defended them publicly.
Right.
And it's like, okay.
How? With what platform, first of all?
Right.
His stuff was not getting the same push that Blake's was.
Right. I did kind of wonder if I hope we get to find this out. Did Isabella get shown that that statement that they wanted Jamie and Justin to post on their Instagram, the one that Ryan and Blake wrote for them? And maybe they said they're going to post this and it's all going to be better because they're going to take responsibility. And maybe what Isabella is saying is that they came back and said they refused to do it, and they said basically, we should just take the fall.
And she took that as, we're just going to let you flounder.
Right.
Fuck you, little woman.
Right. Like that, because I was trying to think where she's getting this idea that they should kind of jump in front of it. Did they think it was proactive? But then I remember they said, post this on your Instagram and take the heat off of us.
Yeah. So
maybe she knew about that statement.
That makes sense.
Yeah.
Yeah, what was Justin supposed to do? Also, like, it was just going to make everybody look bad if he was like, no, Blake's super insensitive comments towards DV, like, she really didn't mean it, you guys. Like, it just undermines the entire messaging.
Right.
So instead, they went to Sony and said, hey, her marketing plan sucks. Look at the public reaction. Can we get somebody to talk to her? And Sony went, I think Josh Greenstein had it out for these guys, personally.
Sometimes you think someone's your friend, and a real friend would say, hey, guys, Could we reel it back in a little bit?
Hey, so you're at an 11.
Should they have sued Sony?
I kind of think, yeah.
Yeah. Okay, so temporal proximity is unnecessary because the record shows that it's causation. I mean, I see the argument. I just don't agree. But doesn't say anything about the causation. Right. So you don't, I mean, if you can prove causation, then yeah, you don't have that 90-day issue kind of coming up, but still.
Right.
So, and then we got the sexual harassment thing. I mean, I guess another thing is, do you think that her claims against Heath are stronger than Baldoni's?
I think that the issues with Heath, given her version of events,
Yes.
sound worse.
Okay.
The problem is, again, you have conversations about birthing on a film set where you're filming birthing, right? Also, I just don't think like a post-birth photo or video of somebody with like their wife and baby is sexual harassment, because if showing people babies was sexual harassment, I am sexually harassed all the fucking time. Oh, you're a single person with no kids. Here's my kid. And I'm like, it looks like every other kid I've seen.
Right. But then you have to
really
be like,
sorry. Once they start to get to 2 and 3, adorable. Couldn't love them more.
Right.
But babies, I'm like, it looks like every other baby. It's bald. There's a tooth, maybe. I don't know. What am I doing here?
Yes.
And that's on being childless.
Right. This is how I feel when people show me their boyfriends. I'm like, he's bald. He has a tooth. Yeah.
There's some hair there, maybe. Yeah, I don't know. I think that's probably her strongest claim against Jamie, personally. But the fact that in her deposition, she said, yeah, go ahead, come on in to her trailer, and then later admitted, I knew he wasn't trying to cop a look.
Right.
I just think it really undercuts. Okay, so you invite him into your trailer. You could have said no. And then you say he looked you in the eye and you knew he wasn't trying to look at your breasts. And she was pumping at the time, right? Or they were removing makeup.
And this is where the witnesses get interesting, because she says she was sitting down. I don't have the full. She says she was sitting down, but she doesn't mention a baby. One of the makeup person says she was holding a baby and recalls like she was breastfeeding on her right side. So she's pretty like clear on, how this was going down. And then the hairstylist said she was standing up. She was in another part of the trailer and she wasn't holding her baby. So we've got 3 very different versions of events.
Yeah.
And they do all agree that she was not wearing clothing. She was topless and wearing like underwear. So I don't know, but it's interesting because this does sound like at one point she was saying they just kept barging in and out of the trailer, and we kind of have it down to this one incident where Jamie was in the trailer. So I don't know if they're conflating it with another person or another time. I mean, it doesn't sound like there's another allegation there. But yeah, the 3 stories are very different, and all 3 women have very specific recollections.
Oh, interesting.
And I will say it doesn't feel coached. Like it doesn't feel like they've had this conversation and they agreed on what to say. But
that's the thing too, right? Like that's the problem with eyewitness testimony.
Yeah.
And when you have an incident where people are coming in and out of an actor's trailer,
right?
Who knows how many times that happened on set? So they may all have accurate memories,
and they're conflating it with another person. Yeah,
they're just remembering different incidents, different people. I think those probably are the strongest claims, but once you start to get into the facts, you're just like,
yeah,
okay, and
yeah. I think if she did say, I know you weren't trying to cop a look, I think that's, that
I invited him in.
Right.
And then you had a problem that he was in there looking you in the eye.
Right.
I invited him in and wanted him to turn around and look at the wall.
Right.
I don't think that plays well in front of a jury.
I also noticed that like one of the witnesses did say like she thought he was checking her out. Lively did say in her deposition that while she said like eye contact, she did say like she did not know if he was checking her out. Like I don't think this is as like clear as just eye contact, because so like think about it, she's at a makeup trailer, right? So it's sitting in front of a mirror and he's
Right.
in the back of the trailer. So when he's looking at her through the mirror, he can see her completely. So it's like he's making eye contact with her through a mirror.
Okay.
So like when he's looking at her, it's not easy for her to see what he's looking at
Sure.
because he's
Right.
looking at a
Okay.
mirror. So yeah, this, and I had to kind of think about like what they're describing. But yeah, so she's in front of a mirror and he's making eye contact
Assuming
with her through the mirror.
assuming she's not standing up like the other eyewitness said.
And well, and yeah, I'll give her that she's the one recalling this, right? That, you
Sure.
know, I think it's just more like that's interesting that the hairstylist is way out there. But, you know, that's what she's saying is like they're looking at each other through a mirror. So when she looks at him through the mirror, now they're making eye contact, right? But she doesn't know how long he's been looking at the mirror because she would have to be looking at the mirror to look at him to see what he's looking at. Does that make sense?
Yeah, yeah. Okay.
So I just to kind of clarify that.
No, that's good context.
Yeah. So
Um,
that's why I think the eye contact versus was he checking me out, why I think that's kind of an issue, because she wouldn't know what he's looking at unless she's looking directly at him through the mirror, looking
Right.
up like to see. Yeah.
Again, I still think, hey, give me a minute. Can somebody get me a blanket or a robe?
Yeah. Yeah.
You know what I mean? Like it just doesn't feel, and maybe there wasn't one available. I
Well,
mean,
and that's actually the makeup artist says like she covered her. She covered the other boob. One had a baby, one had a towel.
yeah. I
So
do
then
remember
it's
that testimony. Somebody said, no, I covered her up immediately. So it's like, okay, now she's not exposed.
right. Right.
I don't know.
But this is all a fact issue. I mean, that would get to a jury if that
Sure.
just on that being a fact issue. Yeah. I do think that's her strongest issue.
Yeah.
Let's see.
The birthing video, like, because it was shown to her after they filmed the birthing scene,
Yeah.
I don't know that there's a creative purpose for it. The
Yeah.
impression that I always got was that they were talking about giving birth and somehow it came up of like, oh, Jamie has like a really beautiful photo or video of
Mhm.
him and his wife post birth, and Blake being fake was like, oh my God, I'd love to see that.
Right. Like, oh yeah.
And then
sure.
was like, ugh, I don't want to see this. Right.
The other thing is Ange Gianetti saw the video as well. So I'm curious if he goes around showing this to people.
Right. I mean,
Yeah.
these two do seem like becoming fathers was the best thing they've ever done in their entire lives.
Mm.
Like both Justin and Jamie very much seem like man who makes fatherhood his entire personality. No judgment on that. Like good for them, you know.
Right.
Dads who love being dads are good dads. I have one. It's awesome. Like no notes. 10 out
No
of 10.
notes.
Yeah,
But
10
yeah,
out of 10. So
it's-
I don't know. I could see it sort of being a like miscommunication, but it is interesting that like there really is no creative purpose for showing her the
Right.
video unless they were talking about shooting alts or shooting like adding something to that scene later
Yeah.
that maybe they thought they had time to do.
Which we haven't seen alleged. I
No.
haven't seen Wayfarer bring that up. So I don't think I think this was more like a recreational video.
Right. And it might be disputed fact as the timing of when it was shown.
Mm. Yeah, it's true.
They may be saying, no, we showed this to her before.
I don't think they are. They have the date and they would know when the
Okay.
birthing scene was filmed. So
Okay.
she did, there's a huge dispute as to what was shown, obviously. She said she saw a lot more. I won't go into what she said she saw, but there's a text message that she sent like on the day or close to the day where she was like, this is what I saw. And
Yeah.
it's very graphic. So
Yeah, what she says she saw and what she saw. You know, again, mothers, right?
right.
She's given birth. Like, why is this offensive to her?
I'm more interested in the fact dispute here. I'm more
Sure.
interested in this isn't something you accidentally think you saw.
Right.
So
No, agreed. It just is one of those like armchair psychology things. Like I would
of like
love, like her issues around motherhood are fascinating to me.
I think there's a lot of self-consciousness around the pregnancy and birth stuff for sure.
100%. And the fact that Ryan allegedly, in my opinion, only kept her pregnant in a very abusive way when she very clearly said, I want to focus on my career. I don't know. Anyway, fourth cause of action.
Fourth cause of action. Let's see. Well, so okay, a PGA letter. Let's see. Okay, retaliation. I think we kind of already talked about this. Yeah. Fifth is another retaliation thing.
And keeping in mind, these statutes, FIHA, right? FIHA requires her to be an employee.
Yes.
So,
yes.
And that's why earlier on the very first page, I talked about the Reed factors. The Reed factors are discussing what you need to prove to show that somebody is an independent contractor versus an employee.
I will say there are some limited extensions to FIHA for independent contractors, and I think they revolve around the film industry. I think there's possibly some, I way early on in this, I looked at some case law where they said even if they're an independent contractor, maybe some of these things apply. This would, I still think, require Lyman to extend FIHA, which I think is the problem for him. I think he's not wanting to do that. But yeah, I mean, for the most part, it is like, I think the bigger issue is, can those FIHA claims, does California law apply to her?
Right. Right. And so that, again, going back to the PGA letter really cuts against her because we're looking at the hiring party's right to control the manner and means by which the product is accomplished. Right. So we already see Blake has control over the manner and means. She gets them to film in New Jersey as opposed to Boston. She's getting them to change
the schedule.
Schedule. She's getting them to, change the script. So the skill required, I don't really think that's gonna cut either way. You can drop in the comments what you think Blake Lively's skill level is at. The source of instrumentality and tools, right? So
her own costumes, right?
Her own costumes, right?
Wood and bone.
It's bone on wood.
It's bone on wood.
Yeah, I mean, they're providing the filming mechanisms and all of that, but at the end of the day, she's controlling some of that. The location of the work, we talked about that. The duration of the relationship between the parties. Yeah. She had a lot of control over that. I mean, she straight up said, I'm not going to promote this movie.
Right.
If she had the control to do that and not be in breach of employment contract, right?
That's a lot of control.
That's a lot of control. Whether the hiring party has the right to assign additional projects to the hired party. So, can they give her more movie, right? Can they give her more scenes? Can they give her stuff, which, she's talking about, she's making changes to the script and, she's controlling how much more work she takes on. She controls when she takes the work. The extent of the hired party's discretion over when and how long to work. I mean, she took off time to go to the Renaissance movie, right? Like, I mean, she has so much control over her workday. The method of payment, the hired party's role in hiring and paying assistants, whether the work is part of the regular business of the hiring party, whether the hiring party is in business, the provision of employee benefits, and the tax treatment of the hired party. So those are what we're looking at when we're talking about employer relations, right? And you can see how a lot of these facts will kind of fit into several of those different criteria. So if the court says she had a lot of control, she's not a traditional employee, right? Because an employee shows up, they clock in, they do what they're told, they go home.
Right.
An independent contractor says, I'm actually going to wear whatever the hell I want. I don't have to wear your company uniform because I'm not your employee. I get to do the work on my time because I'm not your employee. So that limits FIHA and some of these California claims that she's bringing. So
I think she's an independent contractor. I think after that PGA letter, that's it. That's the independent contractor argument.
I agree. I think that PGA letter just cuts against her in so many ways.
I mean, like, not actually Golden said, imagine if we had that at the beginning. How different this conversation would have been. But let's see. So failure to investigate. This is one of those claims that I'm just like, I cannot believe she brought when she has something from an attorney saying we are waiving the right to an HR complaint. But yeah, what they're saying is there is no standalone employer liability for failure to take reasonable steps unless they plead and prevail on the underlying claims. I did not know that. That's interesting that she has to win on harassment or retaliation for that to work.
Oh, interesting.
And
okay.
Yeah. She can't just have that on its own. She can't just say you didn't investigate because you have to have damages.
Sure.
So you have to show that they're not, and that's, I think, what she's arguing, right? I think this is more like failure to investigate, prevent, or remedy harassment. I think the reason why she's thinking this is okay is because she's saying, had you investigated, you wouldn't have retaliated.
Sure. Okay.
So it, like I see the vision, but it's, I see Wilkie Farr and Gallagher's vision, or Manhattan Phelps, whoever wrote this.
Also, if the protected activity is the premiere of the movie, what the hell are they going to investigate? There's no more filming.
Right.
This is it. We're showing up to this premiere, and then we're never wanting to see any of these people again.
I mean, does It Ends With Us LLC have an HR department in August of 2024?
Right.
Do they have an organizational structure anymore? I mean, that's the thing. Was she employed in August?
Right.
Is still, I think, an interesting thing that they didn't really address. But yeah.
I mean, if she doesn't have to promote the movie, you know, if she's just there for funsies because she wants this thing to succeed.
Right.
I don't know. Yeah. So as far as failure to investigate, I bring up the in lieu of formal investigation, that 17-point list. So good facts for Blake. The Plank and Lively texts, I don't think look good for Wayfarer.
Yeah.
People have their opinions about that, but just the plain face of the text look like, oh my God, these guys are being creeps. And I told them and I reported it and nothing is happening. And Liz says, wow, I'll call you or whatever. So, and they didn't stop filming to investigate when stuff was brought up through Ange. So Blake told Ange some stuff. Ange told them. And everybody collectively, Wayfarer, Sony, everybody said, let's keep filming. And keep in mind, on a movie set, every single day, every single minute that you are not filming, you are losing money.
Right.
It is not just we can put a pin in this and come back to it whenever we feel like it and we can take a break for funsies. That costs thousands, hundreds of thousands, maybe even $1 million a day, right? I might be exaggerating a little bit with the million, but it's
I don't
expensive.
think, for some projects, I'm sure you're not. Like, it's just, if we don't do this in the next 24 to 48 hours, it's not getting done. And we have to scrap a huge part of the film. So I don't know in this case. I mean, one of the things in the PGA letter, she said she ran up the budget by the minute.
Yeah.
Like, it is expensive, and that's kind of how it works. I also don't understand this whole, I brought an HR complaint to Ange. Okay. So then she said, no. Did you bring it to anyone at Wayfarer? Or like, did you go to SAG? Why didn't you do anything else? Like,
yeah,
I don't.
Her not going to the union, I think, really strikes against her, because if it really was as bad as her text messages to Liz make it seem, why are you just sitting around and doing nothing?
Right.
So
if she had gone to SAG for, I think there was another sexual harassment complaint she had on another film with a makeup artist. I don't know that she went to SAG. Could that be admissible? Like, to show that she knew the process? Like, if it goes against her credibility here when she says, I didn't know how to do anything, could they impeach her on that and say, on this other film?
Yeah, I mean, I think you can, right? It has to be for that limited purpose, though, right, of showing, but you knew you could go to your union. Now, that's a dangerous question if you didn't ask her that at a deposition.
Right.
So, yeah, that would be an interesting line of inquiry. I really want to read her deposition.
Same.
The fact that we haven't, The fact that we haven't seen it is kind of crazy.
Just take the address out and leak it. I don't need to know her address.
The other part about failure to investigate is she weasels in, and yes, I'm calling it weaseling. No offense to weasels. Adorable little creatures. She uses text to the prayer group. And I'm just like, one, you didn't know that was happening. So she's saying he's repeating all this stuff to his prayer group, knowing that she finds him a creep, right? And so he knows this stuff is going on and he's still not doing anything about it. He's not investigating, right?
Right. But is he the person who would be investigating?
No.
It would be HR, right? Like it would be, yeah.
No, and here's the thing. If the person you have a problem with on you at your workplace is the head of HR,
yeah,
right? And the person you normally would report to someone else.
Right.
Report to somebody else's boss. Go to somebody else that has authority within the company, right? Like, it's not like we're talking about a company with a couple of people.
Right. There's other producers. There's other, I don't think we've seen anything with her and Alex. It's weird because you've got Alex Sachs asking Jenny, do you want to file an HR complaint? And then you've got Lively and Ange is like, I'm not taking a complaint from you.
Yeah.
And I'm like, why didn't you guys swap? Like, did you guys not talk about your complaints?
Hey, I went to Ange. I felt like she didn't do anything. Well, I went to Alex and she told me to do something. So maybe go to her.
Yeah. Like, Jenny was like, Jenny says, Alex overreacted and Ange underreacted. So maybe we need to start. Yeah.
Yeah.
I don't know.
I thought that piece about the prayer group, though, was really just her being mad that they have faith.
Right. And also, I mean, I will die on the hill that she was, I know we don't talk about this case, but I will die on the hill that she was hoping for a Depp Bettany moment where, they're saying, let's kill her and burn her corpse. And then what you've got is Justin Baldoni texting Rainn Wilson saying, pray for me that I have to interact with this woman.
Right.
And it's just like.
And keep in mind, right, he's getting sick. He is eventually hospitalized from how they treated him.
Right.
So in that context, like, I can understand out of context, everything Blake says, everything she brings is like, oh yeah, that is bad. But then you put it in context and you're like, that's your proof? Right? And
it's like Bocce says, technically true, contextually false.
Right. God, I love Bocce. Yeah, it's just one of those things where it's like, we've been asking men to have healthy communities and friendships and to be emotionally vulnerable with one another. Right. And then when they do, it's not feminism.
Right. It's, oh, well, you're shit talking with your friends. And it's like, okay.
And he wasn't. He's literally saying, pray that I have the strength to get through this.
Yeah.
Crazy to me.
Okay, aiding and abetting harassment. I really feel this is getting dismissed for this is Abel, Nathan, and Tag. I just don't think they have a duty of care.
I agree.
So
her best bet is to bury her texts.
Mm-hmm.
Right? That's her best evidence. Spoliation, she doesn't really bring up any other proof. For a lot of these motion for some arguments on her opposition to the motion for summary judgment, there's not a lot of proof presented.
This is the voluminous evidence. Is these New York Times text messages.
That was it. And just so everyone knows, the party bringing the motion for summary judgment is really trying to stick to undisputed facts. Mm-hmm. Things that you just cannot argue against. Because the second they can say this is a disputed fact, it calls into question everything else in the motion in the judge's mind. Right? Once you start to be able to say that's actually disputed, that should go to a jury, a judge is going to start to lean towards, okay, we'll let this go to a jury. In an opposition to a motion for summary judgment, you are throwing your best evidence at the wall. Right. You are saying, judge, look at this. They showed me their privates and they forced themselves into my trailer when no one else was there. And they sent me these sexually explicit text messages and they're saying they want to grape the other actresses. Right. None of that is allegations here.
Right,
But, like,
but
that's
you put stuff.
everything and anything, because if you have something bad enough, the court is going to go, ooh, maybe a jury should hear this.
Yeah.
Even if it's not something that's totally disputed fact, even if there's like some questionable stuff, we're going to let a jury hear it, right? So this is in your opposition, you are throwing in your best evidence. So just all that to say, we have not seen all of Wayfarer's best evidence, I think, but we have seen all of Blake Lively's best evidence. And I don't,
agree.
Yeah.
Especially like with the expert reports, there's nothing in here. The only thing that is in the expert reports that I don't think I saw a lot of in the motion for opposition is that Jed may have boosted some TikToks when they were saying, let's flag this to Jed. He may have used the paid TikTok feature to boost some of those TikToks.
Oh, interesting.
It's like, it's in passing though. Like they don't really get far into that. And I'm like, that's the first thing that I think I've heard that is like, he boosted something. Like, oh, like, and you can just do that. You can pick a post on TikTok and pay $6 to get it more views.
I did not know that.
You can do that.
I've been on TikTok for 4 years.
Yes, you can. Sometimes it'll come up for me, like it was coming up on my For You page, like pay $12 and we'll get you 100,000 views on this. Not that much, but it was something.
I knew you could do it for your own posts. I didn't know you could do it for other posts. Interesting.
I have not seen that, how to do that for other posts, but that was something they kind of mentioned in passing, that they believed he was flagging them so that he could boost them. Now, there's no evidence for that, but one of the experts mentions it like it's a thing. And I'm wondering if it came up in a deposition, because they were texting and saying, flag this TikTok to Jed. And I'm like, what does that mean? And it's like, it means that they're actually doing one thing. But then they don't go very far into that. And part of that's because I think the smear campaign expert evidence isn't on TikTok. It's not, they're not doing it that way. So, but yeah. But honestly, everything else, it comes back to these New York Times text messages that I think have been arguably somewhat debunked. You know?
Right.
Or at least are heavily out of context.
The wind was taken out of the sails a little bit, right?
Mm-hmm.
Yeah, out of context, we can bury anyone sounds terrible.
Right.
In context, especially knowing that some smear articles are coming up about the Baha'i faith, about Justin, about Wayfarer Studios, right? And they're thinking Blake and Ryan are planting those. Nice pool. Right? You have all these things where it's like you have these two very hostile, aggressive, very powerful people with a lot of control, with all A-list friends saying, we are going to destroy you if you don't give us everything we want.
Right. But I mean, that's also the bury her stuff between Nathan and Abel, or the Jed Wallace is doing this with Katie Case. That's their causation for Wayfarer evidence. That's their evidence that Wayfarer paid for this. It's not stuff that like Baldoni and Heath are doing. It's just the two publicists talking about how much they hate Lively. And it's like, okay, but that doesn't prove that the employer is paying for it. Like, what do their text message? I need their stuff. I need Justin or Jamie, probably Jamie.
And again, everything that's in writing between Jamie, mostly Jamie, although there's a couple from Justin.
Yeah.
Explicitly say, do not smear her.
Right. Don't go after her. We
don't go after her, which falls in line with their beliefs. And throughout a lot of this case and with the evidence we've seen, their behind the scenes actions really do comport with their stated beliefs.
Yeah.
Not always perfectly. Do they make decisions in retrospect maybe they shouldn't have made, like hiring Blake Lively?
I mean, but
at the end of the day, you really see them like lifting her up when she gets a good story in this time, right? In the August time period. Like, you just see so much that they don't.
And it's good for the film. It's good for the film if she gets a good review, or if people like her. Like, it's not just like, oh, we're all hugging it out and we're kumbaya and we think Blake's amazing, right? She's the lead in a film and she's running the show. So we need her to do well because we need the film to do well.
Right.
You know?
So we can do well, pat ourselves on the back. Fine, we got through this, move on.
And never make the sequel.
And make the sequel with entirely different people.
With none of the same people. Okay, so let's move on to breach of contract. What are you thinking? My theory was that they were going to kick it all to breach of contract.
I think a lot of it goes to breach of contract. I didn't even really make notes. Partly because it was the same thing. I think she's got a really strong, if the 17-point list is an enforceable contract, which I don't think it is, I think
Right.
she's got a good breach of contract claim.
If he throws that out, do you think it's more likely that harassment retaliation go through, or do you think he's going to throw all of it out?
It's hard for me now because I saw Not Actually Golden on Dave Neal say that she's like 30% chance this goes forward.
Hmm. Oh.
I
Oh,
think it's a
God.
very low chance some of this goes forward, but I also haven't been practicing as long as her. So now that that's in my head, that's sort of where I've settled. And I don't know if that was my original thought or her original thought. I will say, after everything got unsealed and I read the unsealed oppositions from Blake Lively, I was like, there's no way. There's no way. I think breach of contract is one of her stronger claims.
Yeah.
For the contract writer. I think for the actor loan out, she maybe has a decent breach of contract claim, but I just don't see it. I don't know.
I also wanted to point this out because it says, if anything, redacted is compelling evidence Lively knew they had not waived compliance with the conditions present. I have not come back and seen what redacted is, but I was annoyed that they redacted because they're like, if anything, redacted. And I'm like, I need to know what's back there. But yeah, that could be a fact issue. And whether or not a contract was executed and enforced is often a fact issue, I think, in like weird cases. So, okay, so this was just kind of the arguments, the contract stuff. She withdrew those. How do we feel about that decision now that we're at the end of this? What do you think about her withdrawing those?
The intentional infliction and negligent infliction of emotional distress.
Yeah.
I mean, after seeing what this case has done for her reputation,
Yeah.
I'm happy for her that she did.
Yeah.
Because people being able to dig into her private medical information. Now, some of that would have stayed redacted. I think the judge would have agreed that that was private information. But as far as stuff she was going to rely on for the sake of damages for this case, you cannot keep that redacted forever.
Right.
The public has a right to know, which Lyman has made very clear. If you're going to rely on it, if it's relevant for this case, it's not getting redacted. It's not staying redacted.
Do you, and I guess because this is where it's like, I just have noticed this. I'm obviously not an attorney, but like, do you, because my understanding is that the end of your damages for some of this can stop at the beginning of litigation. That like once the lawsuit is like an intervening factor, like you have filed a lawsuit, the damages claiming ongoing damages can be complicated.
Yeah. I mean, it really depends, right? If we're talking about just emotional infliction of emotional distress and that kind of thing. Yeah. I mean, it's hard to say, like, we attorneys, judges all know how stressful this is. So it's a little disingenuous to be like, I brought this lawsuit and it's causing me distress. And it's like,
right. And then my
sucks,
question though,
but you had the choice to not.
You had the choice to not do it. But then my other thing is, do you think that would have made the Van Zandt stuff more at play? Because the argument is she wasn't involved in litigation just in December. It was September 27th, which cuts down her window for damages, right? Because as soon as you started filing the Van Zandt thing, is it the stress of the litigation or is it the stress of the smear campaign?
Right.
That's
interesting. That's an interesting point. I feel like I need to think about that.
Okay.
Yeah. It depends on the emotional distress though, right? We never got any evidence of that.
That's true, right.
If you have somebody like Blake's been in Hollywood, she's probably suffered abuse by other directors, right? And so if this triggered something to the point where, you know what, she powered through it, she got through the movie, and then she wasn't able to feed her kids. She wasn't able to get out of bed. Even now, to this day, she struggles to get out of bed. I think you could bring that in and say, you know, it's ongoing. right? The distress, because it's so acutely triggered this incident that happened to her on set before.
Yeah.
Right?
Yeah.
But you need some sort of doctor to certify that's happening.
Right. And then you get to cross. You get to do an expert rebuttal.
But I think that, yeah, damages don't just get to go on forever. You do have, especially with emotional distress, it's like, okay, well, you pay some damages there. It's not like you lost a limb.
Right.
Which is very interesting because there's a lot of study showing that emotional abuse actually can be a lot more harmful to people in the long run than a physical abuse, which is a very interesting just thing to keep in mind. Like, so the law is like, well, you know, with emotional damage, like, we can compensate you, get over it. Like, the law is very regressive in that way.
Right.
Just an interesting little another problem with the law.
Right. Yeah.
Yeah, I think she was smart to have withdrawn these. I don't think she had another choice. The damage the internet would have done to her.
Yeah.
And she would have found some sort of therapist or psychiatrist or psychologist or she would have found a doctor to say, you're going to find this diagnosis for me. The problem is that they get to find a doctor too.
Right. And then
who gets to
they
do
can
an
ask
analysis.
all sorts of, I've seen this play out where they can ask all sorts of questions. I mean, they can say, how's your sex life? How was your sex life before? Were you and your husband ever considering divorce? You know, like before, because all of that goes into your state of mind. So how's your marriage? Did your husband want you to work again? You hadn't worked in a long time before you did this film. Did he have any objections to you going back to work after your kid?
Yeah.
You know? Yeah.
Yeah.
And
as much as I don't have much respect for Blake Lively, I think she was smart, and I think that was her best move throughout this entire case.
Her smartest move in this entire case is withdrawing some of her claims.
Apparently, there's somebody out there claiming to be a lawyer who said, you know, Blake Lively really should just withdraw her complaint at this point. And I was like, I thought you said you practice law. That's not allowed.
And I just, for the people still here 2 hours in, she has not been able to withdraw since they answered her complaint. Like, it's not recent. It's not like, well, now that they've done oral arguments, she has been stuck here for almost a year.
Yeah.
Like as soon as they came back with just an answer, I was like, well, that's not what I expected Wayfarer to do at all.
And, you know, at first I was like, why the fuck are they not moving to dismiss this? And now I realize it was more important to them to get the truth out there. And let this go on. Let's go through discovery. We're not going to move to dismiss until after discovery. So I think Wayfarer actually was very smart in that way. To trap her into this. Like Emily Baldoni said, she made her fucking bed.
And this is why I'm still saying, like, they were never going to settle, because after I saw the Sony text message where the CEO of fucking Sony is saying no plan works with her. It's the terrorist thing is like, you know, I know that's kind of showy and people are like, oh, she's a terrorist. But him saying no plan works with her. We explained to her how it's going to go and she just doesn't accept it. That's also why they're not settling. She's going to sign an NDA and then say it's a Darvo tactic in the media 2 days later.
Sure.
And you can't settle. She won't do it. Like she'll say she'll do it, but she won't do it.
And she has a long history of doing this.
Right.
This is not the first movie she has taken over. This is not the second movie she has taken over.
Right.
And tanked.
Yeah. This is just the first one that's done well.
This is just the first one we're talking about because there's a lawsuit. Yeah. So, yeah, I mean, she's just not a person that takes direction.
I mean, the real smear campaign are the friends we made along the way.
And here Sara and I are. 2 hours later.
2 hours later. Okay, so false light, invasion of privacy. What are your thoughts?
I think we covered that a little bit earlier. You know, a lot of the smear campaign is stuff that she said and did. Right. Talking about her marriage and her prior interviews and all that. I don't know I don't know how she gets around that. I mean, it's defamation light, right?
Right.
She still has to go through the defamation.
Yeah, she has to prove malice, and I think
She has
that's
to.
Yeah.
How do you do that?
Yeah.
Even if they did do all this, it's like, well, how is it malice to talk about your wedding? Maybe because you shouldn't have gotten married where people were trafficked and murdered and tortured.
I mean, what is she gonna say? But the venue was cute. It's where they filmed The Notebook.
The amount of people that are like, it's where they filmed The Notebook, and I'm like, she told you to think that.
I just,
that's her PR.
Now I'm wondering where Taylor's gonna get married.
Also, The Notebook is not. I'm sort of a romantic movie hater, but
the
Notebook is like not a romantic movie. That's not relationship goals.
I haven't seen it, so
they fight the entire movie.
Maybe it's relationship goals for Lively and Reynolds.
Sure, great.
That could be relation. I mean, their whole thing seems to be sarcastically shitting on each other
and never stop talking.
The other thing I did want to point out that Wayfarer's argument is it's New York, you can't use that. And if it's California, you don't have standing because the California Constitution expressly grants Californians a right of privacy. And then this is where she comes back and says the California Constitution says it applies to all people. So we are all Californian.
That's right.
Yes.
Welcome to California.
Yep.
Yeah.
Welcome to California. If you're watching this and you're still here with us 2 hours in, you are Californian.
Oh.
So, and then we've got another sexual harassment.
Like cowabunga. I don't really know what a Californian say.
we go surfing. I don't know. I think I showed you I grew up like 3 miles from her. Let's see. And so, yeah, I mean, we kind of have the same sexual harassment claims. I went a bit more into the McSweeney thing where they were saying like Andy Cohen saying that Leah McSweeney, talking about her implants or calling her a housewife wasn't derogatory.
Right.
And kind of the same thing. And then we've got the defamation per se, which is this is all centered on this Friedman, what are called the at-issue statements. And I think we've already talked about that. They did say it's a constitutionally protected opinion, which I thought was funny.
I would love for that to be the claim that goes forward. I think that would be the most hilarious case.
That is a funnier outcome.
She would just get pounded at trial because now he just gets to bring in anything and everything to prove that this is why I think the statements I made were true.
I didn't think of how. Okay, I lied. I said defamation's going away, but now I want it in because it's funny.
Yeah.
And then they also said like the CRA, I was gonna say the Civil Rights Agreement, the Civil Rights Act, the 17-point agreement. It's expressly forward-looking, even accepting her spin on the document. It's showing that they knew complaints were raised, not that they knew they were true.
Right.
So, and then First Amendment stuff, permitting a defamation claim to proceed to trial based on an attorney's blanket denial of serious accusations raises a First Amendment concern. And then we've got the civil conspiracy. I think we already did that. What did you think of her damage stuff?
Her damages are crazy.
I love damage awards. I've done 2 papers on damage awards and jury perceptions of damage awards. I
just to say that an independent contractor who has their hands in all these different honeypots, if you sexually harass them and retaliate against them, now you have damages for all of their stuff.
Yeah.
That is a crazy overreach, just generally speaking, right?
Yeah.
Now we're getting into some of this stuff requires her to have a good reputation. There's morality clauses in the contract. So I kind of get where it's coming from, where like if they intentionally smeared her in the media by painting her in a false light,
right,
which again requires malice, then yeah. All right, I can see where you've done damage to her because now this morality clause is triggered because it looks like I'm a huge racist in the media.
Right.
Problem is that's true. So,
right.
If I think you've done a lot more as far as looking at the damages. What do you think?
I I mean, I think it's fascinating. I think it's very clear to me that Family Hive in particular wants no fucking part of this. Her damage experts are saying, first of all, we were thinking of shutting down Betty Buzz anyway. So they're not even alleging damages. Her damage expert didn't even look at Betty Buzz because he said they were going to shut it down because it's not profitable. So
Betty Buzz is its own set of damages.
Its own set of damages, right? Then they're talking about the Betty Boos. I will say this. I do think that they have a fairly good claim that, so the Blake Brown, let me start with Blake Brown. Blake Brown, I think the problem is the damages are too speculative. She had a really good launch and then people did not repurchase. And I think it is too hard to figure out if they didn't repurchase because they just don't like the product, or if because people were boycotting Target, or if they just kind of weren't as interested or whatever.
Oh, that's right, because she had an exclusive deal with Target, didn't she?
Yes, they're only sold at Target.
And it came at really bad timing because Target was like, fuck DEI, and people were like, fuck you back.
So there's part of that, you know, but I also think it's like you only have like a month or two of launch sales. The launch sales were incredibly high. Oh. They were like 3 times higher than they were expecting. So they're saying, well, this means that it was going to sell. And it's like, on the one hand, that does mean that. On the other hand, it could mean that you're also now comparing it to just an unusually high launch. I mean, it wasn't like insane. It was higher than projected, way higher than projected, but it wasn't like insane, right? But it was the largest launch that they'd ever had. So you do see this decline. It's just really hard to say because it's when people would have been running out of the product, right?
Again, you're getting back to, we have causation. To prove that whatever breach or whatever, breach of duty, breach of contract, whatever, retaliation caused these damages, specifically caused these damages.
Right.
And if you give a jury a couple other reasons to say, this could have been because of the boycotts from Target, this could have been, right, and you get all that in through the expert.
Yeah.
Well, you'd agree with me that at that time there was a boycott of Target. Did you consider that in your report?
Right.
Boycotts would be the kind of thing you would consider. So just undermining that credibility a little bit, giving the jury just enough reason to be like, well, I don't know that she should get these damages because.
And yeah. Now, with one thing I did find a little more compelling was the Betty Boos stuff, right? Which is that they see like a lower, this is supposed to be their high part of the year. August to December is like their ready to drink stuff. That's when you normally see an uptick in sales because of the holidays and end of summer, people are having parties. Like, so they were saying we should see an uptick in sales. It also was selling really well. Like they were thinking of shutting down the non-alcoholic stuff, but the booze stuff was selling fairly well. The problem is, and it's universal, it's all stores, which I also thought was compelling. You know, it's not one store suddenly didn't stock them anymore. It's all the stores seeing a decrease in sales. They also said some of their vendors were concerned about Lively's reputation and kind of said, we're just keeping an eye on the sales and we're keeping an eye on the situation. So, okay, we've got some causation. I think the problem is that fucking party, the Betty Boos themed party, because the Baha'i don't drink. So I don't think Wayfarer has anything to do with that party. I don't think there's any Wayfarer sponsored anything about that party. And the reason why I think you don't see Betty Buzz's sales were completely unaffected. Which this is where that actually plays against the booze part, because the non-alcoholic brand, no effect in sales.
Right.
Because they weren't the ones associated with this insensitive party where they're naming a drink after the abuser.
Sure.
And I actually think this is where, even though they're not using them for damages, the fact that you don't see that downturn in sales actually plays now against you, because you're saying, well, what happened to one brand that didn't happen to the other? And it's that party. So it's not just her reputation, because then you would see it with all the brands.
It's her reputation specifically from what she's doing.
Exactly.
Got it.
And then, so the question then is, okay, so if you can parse that out, what happened with Blake Brown? And this is where it's like a jury is going to have to sit through it while they show all of the comments and all of the reviews, which is her hair looks like shit.
Yeah.
It's like, and it's just comments saying, why would I buy hair care from her? Her hair looks frizzy.
Her hair looks like my hair on a bad hair day. And if we're all very clear, I use almost no product on my hair.
Right.
Because I don't care.
Right.
I'm also just tired of losing the battle, but like,
Yeah.
she's a Hollywood actress. And one of her signature things about her is this
her hair.
long, luxurious hair.
Yeah.
And her hair looked like she woke up on the wrong side of the bed and didn't bother to fix it.
And I mean, I think too, a lot of other people are, because I think people are smart consumers nowadays. Like with my hair, I don't do anything to it. This is genetic. And when I was younger, people were like, oh, how do you get your hair like that? And now that I'm like older, people are like, it's genetic, right? Like because they've tried every product, they've tried to do it. And it's like, yeah, this is genetic. Yeah. This is just how your hair looks. And you don't have to do that, So they're saying, oh, am I supposed to believe she's not wearing extensions? I do kind of wonder if that is something they could ask. Like, do you wear extensions?
Right.
Like, is it your real hair? Like, because that seems to be another thing is like, oh, I don't believe that she uses Blake Brown,
Right.
And that's what you're seeing in a lot of these comments. And then, of course, we still don't have the causation. Even if people are saying negative things about the brands, you still have to prove that they're motivated. First of all, that they're motivated by her reputation, because a lot of the comments they're pointing to are talking about the product. So it's like, how do you prove that they don't have this genuine opinion and that it's because they don't like her? And then also you got to prove Wayfarer.
So she has this initial spike in sales with Blake Brown. Mm-hmm. And then she's saying the hit to my reputation hurt the product. But you already had people in the door buying. And one thing I will say about people who find a beauty product that works.
Right.
Like, I actually do have a couple shampoos. It's hit and miss whether or not the CVS has it. But like, I do have a couple shampoos that I'm like, oh, that's a good product and it works on my hair. Once you have me in, I don't care who your mascot is. I'm going to rebuy. If it's a product that works, I'm going to buy it again. I don't care that it's associated with whatever. Now, I mean, for me, I'm not going to buy it because I don't buy racist people's products. But so maybe there's some of that.
Yeah.
But it doesn't seem to be any evidence that like people were like, well, I really like this product. It was a good product, but she's super racist. So I guess I just can't.
Can I show you just like a super hilarious part of the expert thing? Okay. So they were talking about, this is from one of her expert reports. So the expert links this as an example, right, of some stuff that she's getting. And this is from May 25th of 2025, right? So they're talking about the ongoing smear campaign and the ad issue statements. This comment says, you may subpoena all the poor real people who give us real facts and find fake evidence to falsely accuse people and misuse law. But get this in mind, there is nowhere in the whole world where people will like you. We will never forget. You can live in your own bubble, pay whatever money you are left with to have fake fans, but you will know we will never want to see your face again. So this expert used it as an example of like abusive language. Can I just point out the first part she says? You may subpoena all the poor real people. This is from May. This is the content creator subpoenas that she sent out during the litigation.
Right.
The expert does not know this. The expert does not mention the subpoenas. The expert does not seem to know why they're talking about subpoenas necessarily.
Right.
And she's using this as an example of how Brian Friedman's statements have impacted the media when the comment itself is talking about the subpoenas.
An action she took.
Right.
Her own decision, her legal team. Again, an action that I have said probably way too many times is between Van Zandt and the subpoenas to the content creators. I was like, oh, she's just she's the bully. She's the abuser.
Right.
Again, I work with domestic violence victims. I have cases that involve domestic violence. I see how abusers use the system. Mm-hmm. That's Blake.
And, like going back to this chart that I told you is like, I cannot stop thinking about this chart. Look at what's happening in August. That's that orange peak that you're seeing. It all settles down in September and October. And then look at where we are after January 1st, which is that her complaint is when that negative thing upticks again.
Huge spike.
It's higher than it's higher than it is in August initially.
It's higher than the baby bump video.
Right. It's just, and then, you go down to, when they're talking about the Brian Friedman stuff, it's like, I showed you this earlier as well, right? October. So if we have a baseline, 6% of people have a negative opinion of her. at the worst of this, July through September 2024, it's 8%. So we've seen an uptick. It's an uptick, you know,
Sure.
but it's just 2%. And now April to June of 25, it's doubled. We're at 16%. And it's so hard to show that these ongoing damages are going to be from that. You know, they're talking about like they're talking about this Blake Lively is a liar hashtag, and I also think like there's this really high peak on the right hand side where they're saying you know what triggers that second peak is her second amended complaint. So they can't use that second peak because the cutoff date is February the 18th. And this is like February 20th.
Yeah.
So, yeah, I mean, it's just, but also like, if you look, you know, yeah, you're just seeing like, it's coming back to these subpoenas. It's coming back, you know, I pointed out the boycott. This is what I think they'll use in the rebuttal. You know, this is the total. It's 35 million to 97 million in damages. And they actually, I will say, I think she is saying that this is what she's personally going to lose. I just don't think and again, when I go to the causation, let me bring back.
And just everyone, we talked about this before we hopped on, but you know, when we're talking about those charts, Jed Wallace is hired the day the huge spike happens.
Right.
Because he's hired the day the baby bump video drops.
Right.
And then if you notice there's a decline right after that, Jed Wallace is still getting paid in that time.
He's getting paid September and October. So for 2 months, you know, my whole thought was, well, Jed's not getting paid to sit around and do nothing. Well, according to Lively, he is for September and October, which to me would tend to increase the belief that maybe he was getting paid to do nothing, not to do nothing. Obviously, what I'm saying is what he was doing was not something that was having a negative impact on online sentiment. Right. And then when I go back to the causation, and this is where I'm talking about the House of Cards, right? Because the entire thing goes back to Maislin. And when she's talking about her evidence, right, saying like the campaign as outlined is an example. According to documents and communications produced in this litigation, the strategy was designed to be untraceable and involved the deliberate creation and amplification of content that would appear to originate from ordinary members of the public, but was in fact orchestrated by paid agents. And I'm like, okay, and what do we have? We have the same fucking text messages from the New York fucking Times article that we've been talking about. Voluminous evidence.
Right.
Voluminous. I was promised voluminous. And we're back at the original messages. Mind you, Katie Case has testified that she does not know what Jed Wallace did. She was just assuming it was him because, I mean, we hired him, right?
She's like, I don't know. He does stuff I don't really know.
Right. And then there's the whole thing where they're saying, like, there's no bot army. That's a myth these days. Any digital team is far more intelligent. Okay, she's saying that digital teams are far more intelligent nowadays. She doesn't say we're doing anything.
Right.
And whatever they're doing, they decided to stop it 3 weeks in.
And again, a big part of the dialogue has been he hired bots. He has bots on him, you know, which is, again, we have ways of tracking that, and they don't ever say, here's the bots that were boosting this stuff. Here's the way they paid content creators. None of that. There's no evidence of that. The only thing we have is they maybe worked with Andy Signore, Andy Signore, on his documentary. Okay, well, do we know if he reached out to them?
And also the documentary hasn't come out yet.
Documentary hasn't come out yet. Like, it's so beyond.
Yeah. I mean, we're just seeing it. We're seeing it everywhere. And then again, you see this huge uptick when the lawsuit gets filed. It went away. And I like I told you this before we started, but I just wonder if she'd bothered to sit there, give it another month. By September 27th, she was invested in the Vans end of it all. So they were figuring out, we're probably talking to the New York Times already. We're figuring out how to launder this text messages. We've got the Jones stuff on board. We've got Taylor on board. We're doing all this stuff. We're full steam ahead with, I'm going to reverse my cancellation. And Taylor's texting her in early December, you reversed a cancellation. That's so rare.
First time in history.
First time in history. And it's like, if you had just paused, gotten this information, you would have seen it was already over.
And this is how we know Blake Lively doesn't meditate. Had she just taken a deep breath and been like, maybe I can get through this.
Maybe Justin could recommend her.
Without some sort of revenge tour.
I just...
I mean, that's the thing too, though, right? And this is the unfortunate sexist aspect of this case, is that a woman is going to be dragged in the media for bringing these claims.
Yeah.
Even if they're true.
Yeah.
And so whether she wasn't adequately warned by her attorneys, or whether she was and she decided to go forward anyway, her reputation on past sets was going to come up.
Yeah.
And I don't know if she's so deluded to think that the people liked her on past sets. I don't know, right? I don't know if she thought her prior acts to take over other movie sets wouldn't come out. I don't know. But she was going to get dragged for her reputation, for her affairs, for the nudes. Is that fair? Is that how women should be treated? Fuck no.
Right.
But that we don't get to sit around and go, this is the world we live in and it's unfair, so I'm going to pretend I don't live in it and then complain that I didn't know this was coming.
Right. Right.
I'm really sorry, but this is the world we live in, and we have to balance being realistic about the world we live in and trying to change it.
Yeah.
You know, but it just is on some level, and maybe she did really think that they were going to move to dismiss and this would go away. And
I think
you
so.
know,
I think a lot. It's very risky. It's very, very risky. I would love, and we may get to see if she does eventually go ahead with a malpractice claim. You know, I sent you a
come
link
on, girl,
earlier.
sue your lawyers. They're not doing a good job for you. Sue them.
I sent you a link to a Reddit post where someone said, if they do gut her case, like if they dismiss most of it, could she sue her lawyers from malpractice about the FIHA stuff? And I'm like, I don't think whether like she can or should sue has ever been a consideration here. So why not?
Can?
Right?
Yes. Should?
Can.
Fuck no.
Probably not. But yeah.
Yeah. Can you and should you are very different questions. In Arizona, to bring at least medical malpractice cases, I think probably legal malpractice, you have to have an expert report attached to your complaint. So you actually have to get an expert before you even bring your lawsuit.
Oh, that's interesting.
And so I don't imagine it's the same everywhere. That was a big part of the tort reform push, and Arizona's pretty conservative in those regards. We're very business friendly.
Yeah. That's interesting. That, I mean, it also, I mean, I know medical malpractice is very, very difficult to win. Mm-hmm. And so maybe that's not a bad thing, because you need to get kind of clients realistic about.
One of the downsides to malpractice is that with these experts, it's very difficult to get an expert to testify against fellow colleagues in the profession. Right? That's true of medical. That's true of legal. It's very hard to get somebody to come out and be like, that was malpractice, right? Because we've all made mistakes. We've all done stuff that like would rise to maybe the level of somebody not having a great time with you as an attorney, whatever.
Right.
You know, we've all done stuff that we don't want somebody to turn around and go, that's malpractice. So it is very difficult to get people to testify against you. And the people who do testify against you tend to be constantly used by plaintiffs, constantly used by defendant, right? Like, so, you've testified in 700 cases and 698 of those were for plaintiffs. So this is just your bag.
Yeah. So they could hire Brian Friedman, right? Like, she could sue and she could hire Brian Friedman to take down Ezra Hudson.
I would live for that plot twist.
I mean, could they, or is there too much?
He would be a witness.
Okay.
I mean, I guess you could have a witness as an expert.
Mm-hmm. Yeah, dual witness,
but yeah. Look, Blake, your attorneys did you no favors. And I think you should sue them for it.
And I think Brian Friedman, we know he'll take on WME. He can definitely take on Wilkie Farr and Manhattan Phelps.
And, you know, so everyone can get mad at me, Blake is a victim here.
To bad unironically, though, there's some of this where it's like at some, I mean, I know they probably had them sign off on things. I mean, I imagine,
Oh, yeah.
They have them sign off and say, we're doing this. We are advising you X, you are signing off on Y.
Right.
But yeah, I mean, I also kind of wonder, we're going to cover next week to kind of lead into the next episode. We're going to cover Drake and UMG, and that's Mike Gottlieb. And I think he may have a specialty in difficult cases and difficult clients. And, like Not Actually Golden and Little Girl Attorney said he was great at the oral argument. They were super impressed. So it's like, this is a top attorney. This is a very talented attorney taking on, and he did the Giuliani defamation thing. Like he has that's like the highest defamation award ever. I think it's like 600 million.
Yeah.
This is a top attorney and he specializes, and yeah, we can do that. Fuck yeah, let's do it.
Sure. Let's bring it. Why not?
Yeah.
You've got the money. I got the time.
So,
it's, leading into the Drake case, I do think it was very smart that he sued UMG, Universal Music Group, and not Kendrick, because it forecloses the defense of this is true.
Right.
Because what streaming service is going to be like, no, we totally work with this artist who we definitely think is a PDF file, right?
Right.
So they're not going to make that argument. So you foreclose them from the strongest argument you have with defamation.
Right.
So, yeah. Gottlieb, also not my favorite. Although reading his deposition with his questioning of Justin Baldoni.
Yeah.
And the little back and forth they had, I was like, you know what? I don't love the arguments he makes in court.
Yeah.
But also, if he can treat people like they're humans during the process, mad respect for that,
I mean, even Ellen Garofalo, she said something like, we understand that this is the argument your client is asking you to make. Like, she said that in some email. And it's like, my take is, in their conversations between the attorneys, they're getting along. Right. Yeah. They're like, we understand. Sure. This is the situation we're all in. As Jamie Heath put it, we're all in bed with a fucking monster. So Ellen's like, we understand that, and we're moving forward. And I did think, the way Gottlieb kind of baits Justin, reels him in, pounces a little bit. I'm like, yeah, he's good. He's very good.
Yeah. So. I mean, he has to be to do what he does and to work with the people he works with. Yeah. Which is not to say every attorney that works at a big firm is good. Or ethical or just or interested in justice at all. But, he is a top echelon.
It's a tool for the job, right? Like Brian Friedman, right?
Sure.
He's not going to be the best litigator, but you put him on TMZ and he knows what he's doing, and people like him.
And it's a struggle for me to respect people like that, because it's like, my goal is justice. My goal is, keeping our side of the street clean. My goal is to let's get through this in a way that gets everybody through this the best way we can. So
yeah,
it's different goals. They're in it to make money.
Yeah. They've chosen this high profile career, and this is what we get. We get $50 million being spent by each side. We're probably at 70 million, I'd say, for both.
Yeah.
And we haven't even gotten to trial.
Well, my computer's going to die any second.
All right. So thanks for hanging out with us, guys. Next week, we are doing Drake as our episode 3.
Say Drake.
I guess we can't play the song because we'll get copyright infringement, but
yeah, I'll just sing it.
We'll just say, oh God, we're gonna get taken down for that. All right, so thanks for anything. Any last thoughts or anything?
Stay woke.
Stay woke, and don't bring lawsuits like this unless you're willing to see it through.
Ooh, yeah. Don't count on that dismissal.
God, yeah. What a lesson. All right. Have a good week, everybody, and we'll see you next time.
Bye.
Bye.